objection to Mr. Padilla's close?
Yes, you heard correct. Mr. Padilla, I believe, he's indicated that he wants to show the jury transcripts, portions of transcripts. I would object. That is improper, to show transcripts. If they are to rely on testimony, it's to be of their own memory as opposed to transcripts. Even when we do readback, we don't show them transcripts. So I would argue that that is improper for closing.
I would argue that it's actually the norm. I do it all the time. I put it up on for the jury to see. I don't intend to show anything objected to or anything sidebar, but other than that, it's just trial testimony.
Here's what I will do. I will allow you to show that the stuff that you have, you shall not refer to it as a transcript. You shall not refer to it as the official transcript or the recorded transcript or anything else. But if you say, jotted down and typed out the stuff, and as long as you preface it with, of course, you have to rely on your own recollections, but my recollection is this question was asked, you know, if you present it that way, then I don't see any difference between if you'd done that or if you just jotted it down on, let's say a yellow pad.
Okay.
But I don't want it referred to as an official transcript, or this is because again, they're supposed to rely on their own recollection. And the next thing I don't want is, can I have a copy of that transcript?
I understand.
Judge, if I could ask Mr. Padilla to identify which transcripts of which witnesses?
I'll send it.
I think it's a trial transcript that he's been ordering every day.
Right, but
Judge wouldn't allow him to drag Drake into it.
But again, with those limitations understood, I think it's fine. All right, anything further?
nothing from the state.
No, Judge. No, Judge. No, you're not.
All right, very good. We are ready to get underway then. Let us bring them out.
All right, we're here. It's closing arguments. I had court this morning, so I couldn't start with it. But I think I might speed this up so we can catch up to it. This is going on right now. But that's enough of this trial. I want to see the closing arguments. And there are 3 defendants, and I want to see if one or all of them get convicted. They all seem guilty of sin to me. Let's close this thing out, shall we? Oh, yeah. I'll talk with Mike. He has the best ceiling tiles on the webs. That's how we roll. Turtleneck, baby.
Jurors are entering.
Should I put my fez on? In honor of the jurors? Thanks for the endorsement, Ardo.
Parties may be seated. Court will come to order. The parties are present. The jurors are present. Ladies and gentlemen, good morning. Welcome back. I trust all of you were able to follow the court's directions. Very well. All right. We've now come to the point in the
Closing
case where
arguments.
both the state and
Final
the
phase.
defendants have rested their cases. The attorneys will now have an opportunity to present to you their final for closing arguments. I want to remind you now, as I have throughout this case, that what the attorneys say is not evidence. However, do listen closely to their arguments to you. They will be commenting upon the testimony that you've heard and the evidence that has been presented in this case. They, as you, will be recalling the evidence in the case. Now, none of these counsel would intentionally try and mislead you. However, should their recollection of the evidence differ from what your recollection is, you must rely on your own recollection. Each side has equal time to argue to you that the state is entitled to divide its time between an opening closing argument and a rebuttal
Well,
argument.
thank you, Cal Marie.
And an opportunity to argue. So with that, state of Florida, you may close.
Thank you, Your Honor. Good morning. This will be one of the final opportunities that we get, Ms. Buckaloo and I get to speak to you. So we first want to thank you for your time and attention. This case wasn't easy. We asked you at the beginning to commit your time and your attention, and you've done that. And I think on behalf of all parties, we thank you. This is the opportunity that we're going to get. We talked about a lot of hypotheticals at the beginning when we were going through jury selection. But this is the opportunity that we're going to get to actually talk about the evidence that you've heard and how it intersects with the law. Okay? And so I believe at the end, we'll be able to come to the same conclusion, which is guilty as to all three defendants. But let's go through everything. I first want to talk about the law that you're going to hear regarding principles. You'll get instructed on all of the law that I'm going to go over by Judge Uson. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if
Warning.
the defendant had a conscious intent that the criminal act be done.
You're about to learn something here.
Okay? And the defendant did some act or said some words which was intended to and which did incite, cause, encourage, assist, or otherwise, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. So that's what the law is. And you'll recall at the beginning when we talked to you at voir dire, all of you said that you would be able to follow this law. So now is the time that the state of Florida is asking you to do that, to follow this law. Let's talk about how this law, though, is applied to the facts that you've heard in this case. For example, the defendants, and I say plural defendants, renting the Dodge Journey together the day before the homicide. That would be a way that the law is applied because they had to assist each other. You'll recall, Dietrich Williams provided the person who actually rented it. Then Michael Boatwright with Robert Allen went to go pick up the car. That's an example of assisting each other. Going together to Reba Motorsports to purchase the mask, okay? They went in the Dodge Journey. That's another example. Inside the Dodge Journey, you'll recall, they had everything that they needed to rob and kill the victim. There were masks, there were firearms, they were ready to go, okay? And that's a way that they assisted each other, encouraged each other to help commit this crime. Another way, Williams and Allen confirmed that the victim is inside Reba Motorsports. Two of them remained inside the Dodge Journey, Trayvon
She really
Newsom
has been good.
and Michael Boatwright stayed inside the Dodge Journey while the other two go inside to the Reba Motorsports to confirm that the victim is there. That's another example of how the principal theory is implied because they're all assisting each other. Lying in wait for the victim together, waiting for the victim to exit Reba Motorsports. That's another example of how the law is applied to these facts.
It does help when you have a video of the crime.
Planned and executed a coordinated attack on the victim. Think about it, which we'll look at clips from the surveillance video.
Happy
You
birthday,
see
Iris.
The Dodge Journey very quickly cut the victim off. That's the first coordinated part.
That's a
Second
goat screen.
coordinated part. Two of the gunmen quickly jump out in a blitz fashion.
Iris is the best.
Coordinate, go to each side of the car. That's another planned coordinated attack. That's assisting each other, okay? Defendant Williams driving and cutting off the victim so Boatwright and Newsom can quickly jump out to catch the victim by surprise. That's a great example of how principals assist and encourage each other to commit the crime.
Ah, you
Williams
ladies crack me
waited
up.
for Boatwright and Newsom to rob and kill the victim. When the two gunmen jump out of the Dodge Journey, Williams didn't drive off. He's waiting for them. That's to assist them to get away.
That's
So
all they got.
now, after they've just shot and killed the victim, what does he do? He assists them by getting
turn down my
away
volume,
so that
my
they can
mic.
evade detection. And he quickly drives off. That's one of the ways how, even though, for example, defendant Williams is not the shooter, he can still be held responsible like the shooter because of all these things that they did together to assist each other to commit the crime. Boatwright approaching the victim's side of the car at gunpoint, while Newsom approaches the passenger side at gunpoint. Think about this. Why is that? The victim can't get away from either the driver's side or the passenger side. He can't go forward with his car because Williams blocks him off. So the three of them are coordinating an attack to be able to rob and kill the victim in that moment, assisting each other. And ask yourself this: would Dietrich Williams have been able to commit this homicide and armed robbery without Michael Boatwright and Trayvon Newsom? I don't think so. Would Michael Boatwright have been able to commit this homicide and armed robbery without Dietrich Williams and Trayvon Newsom? Would Trayvon Newsom have been able to commit this homicide and armed robbery without Dietrich Williams and Michael Boatwright? If you're able to answer each question as no, then you're applying the principle theory correctly. Because each of them, Dietrich Williams, as a driver, he would not have been able to approach both sides of the car as an armed gunman. He needed them in order to commit this armed robbery and homicide. Michael Boatwright needed his co-defendants to be able to rent the car, to be able to drive off. He couldn't have done that by himself. Trayvon Newsom, he's the other gunman. He needed a second gunman to approach the driver's side. He needed a driver to get away. He needed assistance to rent the car. These are all things where they're acting together.
All right, I'm going to try to speed it up so we can catch up. But if it doesn't work, we'll go back
You're
to
also going
regular.
to get an instruction, I believe it's on weighing the evidence. And these are questions, it's not an exclusive list, but these are questions that you can ask yourself as you're thinking about the testimony that you heard, the exhibits that you reviewed, the surveillance that you saw, and the things that you heard at this trial. Did the witness seem to have an opportunity to see and know the things about which the witness testified? That applies to, for example, all the eyewitnesses, how close they were in proximity to the crime. How about the witnesses that weren't at the homicide? Like, for example, Tanel Carter, who knows the co-defendant and was able to testify because she was engaged to him at one point. Did she have an opportunity to know about the things to which she testified? Did the witness seem to have an accurate memory? That goes to, did they have to be refreshed? Were they impeached? Things of that sort. Was the witness honest and straightforward in answering the attorney's questions? So, if I asked a question, did I get a straightforward answer? Or was the witness delaying or combative with me? Those are the types of things you can think about and look for. Did the witness have some interest in how the case should be decided? So, for example, that would be a Robert Allen, who is a co-defendant who has pled guilty in this case and is awaiting sentencing. And so you can consider that as part of his testimony. But consider this as well as you're thinking about his testimony. Think about all the things that corroborate his testimony. And so you can decide if you find him credible or not based on the other evidence in the case. Does it agree with his testimony? Does the witness's testimony agree with other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or any other benefit in order to get the witness to testify? Example, Robert Allen. His testimony about whether
Thank
or
you.
not he received a benefit for his testimony.
Generous.
Deal from the state. Even if you decide, you know what, he probably is testifying because he wants to save his own skin. I implore you to still look at the other evidence in the case. Does it agree with it? Is it corroborated by other evidence that you'll hear and that you've seen in the case? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? You'll recall, and we'll talk about it in detail a little later. That would be, for example, when Trayvon Newsom threatened Robert Allen.
while he was on the stand. That's a way that you can apply that. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? That's the type of evidence that we talk about when it's called impeachment. Did the witness give some other testimony at some other time that conflicted with what?
Yeah, it's a little fast, but she's still good.
Has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? That would be an example of if the witness told you that they are a convicted felon. You could consider that as part of their credibility. So let's talk about what the law is regarding first-degree murder, because it is the primary count that you'll be deliberating on. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. One, Jose Enfoy is dead. I'm going to go over the counts and I'm going to talk about how the state has proven them. Two, the death was caused by the criminal act of Dietrich Williams, Trayvon Newsom, Michael Boatwright. When you get instructed on this law, it's going to be separated out. But for purposes of talking to you right now, I put those three together. So that's the second element. And three, there was a premeditated killing of Jose Enfoy. So the thing about what I'm going to talk to you about with respect to first-degree murder, there's two ways that we can prove first-degree murder to you. One is premeditated murder. The second is felony murder, which I will get into shortly. To prove the crime of first-degree felony murder, the state must prove the following three elements. It's going to be the same as premeditated murder. One, Jose Enfoy is dead. Two, while engaged in the commission of a robbery, in this case I separated out, Dietrich Williams caused the death of Jose Enfoy. And this is where also, when we talk about the principal theory applies. Because for number two, it doesn't have to be that he actually caused the death. As a principal, were his actions with his co-defendant the cause of Jose Enfoy's death? That's how you apply the principal theory. Jose Enfoy was killed by a person other than Dietrich Williams. In this case, we've alleged from the beginning that Michael Boatwright is the shooter, but both Dietrich Williams and the person who killed Jose Enfoy, which would be Michael Boatwright, were principals in the commission of the robbery. So that's, again, an application of principal theory.
This is the only thing that I think is in doubt.
One of the things I want to talk to you about, premeditated
I think we get 3 convictions.
There's 12 of you that will be deliberating. If 12 of you decide that the defendants are guilty.
But Boatwright's the easy one. He's the trigger man.
You can vote and deliberate and say that they're guilty. You don't have to agree on whether it's premeditated or felony murder. So 6 of you could decide, I think it was premeditated murder. And the other 6 of you could decide, I think it was felony murder. They're still guilty of first-degree murder. Okay, so that's the option that you have and that you can take.
Well, we're headed there.
Now,
there'll be 3 defense closings.
I'm going to spend a lot of time
after this
for both felony murder and for premeditated murder, the second and third elements, okay? Because when we get to Jose Enfoy's dead, that is something that, if you'll recall, Jose Enfoy's aunt identified him as the deceased person in this case, and we'll talk about that. That's an important element that we have to prove, and I submit to you that we did, but there's a lot of evidence that is, that works together to prove elements 2 and 3, okay, under first-degree murder. So I'm gonna spend a lot of time talking about that. This one is with respect to Michael Boatwright. It's a little different because he's the shooter. With respect to the elements, Jose Enfoy is dead. While engaged in the commission of a robbery, Michael Boatwright caused the death of Jose Enfoy. So there's 2 ways that you can find that we've met that element. Number 1, Michael Boatwright is the person that jumped out the car as an armed gunman and was in the commission of the robbery of trying to steal the necklace off of Jose Enfoy's neck. And also, if you'll recall, the co-defendants actually stole $50,000 from the victim. Okay, so whether you say it's in the commission of or it's premeditated, it's still element 2 is proven. And while in the commission, while engaging in that robbery, Michael Boatwright killed the victim. So that's how element 2 is applied. And Michael Boatwright was the person who actually killed Jose Enfoy. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. So remember, when I said 6, it could be 2, it could be 1 of you decides it's first-degree premeditated murder. And the other 11 say, you know what? I don't believe that the state proved intent, but I believe that during the commission of the robbery, Michael Boatwright killed Jose Enfoy. It's still first-degree murder. This is as to Trayvon Newsom. Number one, and the elements are gonna remain the same for each defendant. Number one, Jose Alford is dead. Two, while engaged in the commission of a robbery, Trayvon Newsom caused the death of Jose Alford. Three, Jose Alford was killed by a person other than Trayvon Newsom, which is what we've alleged, and I believe that we've proven, because Michael Boatwright is the killer, is the shooter. But both Trayvon Newsom and the person who killed Jose Alford, which would be Michael Boatwright, were principals in the commission of the robbery. Again, there's that principal theory. And remember those three questions that I asked for you to ask yourselves. Could Trayvon Newsom have done this without Michael Boatwright and without Dietrich Williams? Could Dietrich Williams have done this without the other two? That's how you apply this. In order to convict the defendant of first-degree felony murder, it is not necessary for the state
Orange
to prove
turtleneck.
that the defendant had a premeditated design or intent to kill.
He's definitely got
Count two,
a turtleneck thing.
you'll also get to deliberate regarding armed robbery. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. Number one, Dietrich Williams took certain property of value from the person or custody of Jose Alford. So you'll recall, with respect to the principal theory, Dietrich Williams doesn't have to even be at the scene of the crime. He doesn't have to be the person that reached into the car and grabbed the money from Jose Alford. As a principal, if you find that the law is applied and you follow law principles, then he is treated like his other co-defendants. And so did, by his actions and his co-defendants' actions, take property of value. I think that is without question, $50,000 is property of value, and that it was taken from Jose Alford. Was it taken by force, violence, assault, or putting in fear? This is a common sense approach. Jose Alford was leaving Reba Motorsports, trying to make a right-hand turn out of the parking lot when two armed gunmen jumped out of a vehicle that's blocking him and on each side shoved guns in his face. That qualifies as by force, that qualifies by violence, that's also an assault, and I would submit to you that in those final moments of his life before he was killed, he was put in fear.
Yep.
Three, the property
Preach
taken
it.
was of some value. I think it goes without question that $50,000 is valuable. And we know that it was money that he had on him because he just went to the bank. You heard from Cecilia Ramos, who was the bank teller, who said, and you saw the surveillance that she dispensed $50,000 to him in cash. You saw that he put it in his Louis Vuitton bag, and that same bag he had when he went from Bank of America to Reba Motorsports, and that's what was stolen. And the taking was with the intent to permanently or temporarily deprive Jose Alford of his right to the property. I'm not saying this to be flippant. That money was taken and never intended to be given back. That's how you apply that. Was it permanently taken from him to deprive him of his right to it? It was his money, taken from his bank account. And they intended to steal it from him and not return it, obviously. With respect to Michael Boatwright took certain property of value from the person or custody of Jose Alford. Force, violence, assault, or putting in fear was used in the course of the taking. So that's two ways that you can find it, either with him as a principal, or if you also determine that he is the shooter and the taller of the two gunmen, he's the one on the driver's side that was shoving a .22 caliber rifle in Jose Alford's face. I submit to you that that's forceful, that's violent, that's an assault, that's putting Jose Alford in fear to steal the money from him. The property taken was of some value, and the taking was with the intent to deprive the victim of his right to the property or any benefit therefrom. For Trayvon Newsom took the property of value from the person or custody. If you find, and I submit to you that we've proven, Trayvon Newsom is the second gunman. He's the one that ran around to the passenger side and actually went inside the car and took the Louis Vuitton bag as his co-defendant is holding the victim at gunpoint. So either you find that we've met that element as the person that did that, or as a principal, because remember, as
I'm in
principals,
Jacob in the
we've done
house.
this without each other. I submit to you, force, violence, assault was used
Nice
in the
to see
course
you,
of the
buddy.
taking, and the property was of some value, and the taking was with the intent to permanently or temporarily deprive Jose Alford of his right to the property or any benefit from there. You're gonna get an opportunity. Well, two things I want to talk about before we talk about lesser included offenses. I'm submitting to you that we have proven the highest offenses charged in the indictment: first degree murder and armed robbery as to each defendant. You're going to get the option that if you find that the state hasn't proven the first degree murder or armed robbery, that there are what's called lesser included offenses that you could deliberate on. I and Ms. Buckler are asking you to vote guilty on the highest offenses that are charged, which is first degree murder and armed robbery. But in the event that you want to have other options, this is how I like to explain lesser included offenses because it's kind of hard to grasp.
Oh, good Lord. We are really going to learn
Russian
stuff
law,
here.
something particularly special about it. This is first degree murder, okay? This would be the highest offense. Contained within first degree murder is second degree murder. All the elements would be met for second degree murder, okay? And contained within second degree murder is manslaughter, okay? So just a visual for that. And so each crime that's charged, contained within robbery, armed robbery, or robbery, petty theft, and assault, okay? We're asking you to find the defendants guilty on the highest charge, okay? But you'll get the options. And so let's go over some of the options that you're gonna
I've
get.
never seen the little Russian doll
And it goes
visual.
without
That's
saying.
kind of cool.
We believe that, Ms. Buckler and I believe that we have proven to you that the defendants are guilty of the highest degree charge, but by that virtue, you're guilty of all the lessers as well. So second degree murder is one of the options that you'll get. To prove the crime of murder in the second degree, the state must prove same element, Jose Envoy's death. The death was caused by the criminal act of the defendant, and there was an unlawful killing of Jose Envoy by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. That's a mouthful. What does that mean? So when we talk about that moment that the defendants are holding the victim at gunpoint and shoot the victim, was that a depraved mind, demonstrating a depraved mind without regard to
Florida
human life?
case.
I submit to you it is. Shooting someone in the neck and then leaving them for dead. Manslaughter, that's another option you're gonna get. Jose Envoy is dead. The defendant intentionally committed an act or acts that caused the death of Jose Envoy. So it's two elements. No intent is needed, just simply did the act cause the death of Jose Envoy? And I would submit to you, it did. For armed robbery, you're gonna get the option of petty theft. To prove that, the defendant knowingly and unlawfully obtained the property of Jose Envoy. Yes, like we went over with armed robbery, that it was unlawful to take it by force, violence, or threat. And that the defendant did so with the intent to either temporarily or permanently deprive Jose Envoy of his right to the property or any benefit. Like we talked about with respect to armed robbery, I would submit to yes. Assault. To prove the crime of assault, the state must prove the following three elements. The defendant intentionally and unlawfully threatened either by word or act to do violence to Jose Envoy. I submit to you that that's proven. The act would be holding the victim at gunpoint. At the time, the defendant appeared to have the ability to carry out the threat. Absolutely. Not only did they have the ability, they did. The act of the defendant created in the mind of Jose Envoy a well-founded fear that violence was about to take place. I submit to you, yes. Jose Envoy was likely in fear that violence was about to take place, and it did. So let's talk about the evidence that has been proven by the state. One of the first exhibits that you saw is the driver was Beecher Williams. That's state exhibit 4. Trayvon Newsom was the shorter of the two gunmen. And when we talk about height, you've sat with us for several weeks and you'll be going in and out. When the defendants stand up and out of respect for you, you can look at their height difference. You can see that Michael Boatwright is the tallest and that Trayvon Newsom is the second tallest. And you can gauge for yourself by looking at them in this courtroom, does that comport with the testimony that you heard? Michael Boatwright, exhibit 6. You'll recall, these pictures were introduced because the witnesses identified all 4 co-defendants, including Robert Allen, which is state's exhibit 7. And before I move on, the thing that you'll note, like I talked about in opening, the differences between the 4. Robert Allen is the heaviest set out of the 4. Michael Boatwright is the tallest. That's consistent with the surveillance as the gunman who's on the driver's side of the victim being the shooter. The second gunman is the second tallest, and you can see it when they stand up. Dietrich Williams is the shortest by far out of the 3 co-defendants. You first heard from Cecilia Ramos. You'll recall that she is the Bank of America teller. She dispensed $50,000 to the victim. Bank of America video surveillance was entered through her as exhibit 1. And let me just note this. I may not go over every single piece of evidence in detail. This is meant to highlight, okay? We entered 78 pieces of evidence. You've heard from way more witnesses than I may mention, but this is to highlight so that we can go through the evidence and talk about how it's proven that the defendants are guilty of first-degree murder and armed robbery. She testified that the victim put the $50,000 in his Louis Vuitton bag, and that was also corroborated because you saw it on surveillance when he was at the counter. She described the victim as being in a very good mood. There was no beefs or anything like that happening that day. He woke up, he decided that he was going to buy motorcycles and went to the bank to get cash from his account. And that $50,000 is what was stolen and of value. Okay, so that applies to those counts that we talked about with respect to what was stolen being of value, the armed robbery. With,
I think
the armed robbery elements.
Just getting
And that's
accustomed
how
to
you
orange to
determine
be
that, because
wearing.
you can look at her testimony and say, okay, this bank teller, you find her credible. She says, and I saw in surveillance that $50,000 was dispensed to him, and that's how I submit you. We've proven that that's what was stolen and of value. As I said, it goes to the felony murder element and also armed robbery element. Leonard Kerr, you'll recall, he's the uncle to the victim's younger brother. I think in opening I called him like kind of like a step uncle. He met the victim at Bank of America, and he was asked there by the victim's mom in order to accompany him, so that if the victim did buy a motorcycle, that he would have someone to drive back the motorcycle and then someone to drive back his car. He drove to Riva Motorsports with the victim, and he was witness to the armed robbery. He detailed to you how the attack occurred, and that's corroborated by the surveillance, because as the passenger, he said out of nowhere, coordinated attack, remember the principal theory again? They're cutting the victim off. And that you can see that from the surveillance, which I believe is Exhibit 2. He describes a taller gunman as being on the driver's side, that would be Michael Boatwright. And he detailed how the gunmen were yelling at the victim, cursing at the victim. This is when we talk about, was it by force, by violence, the assault. This is how the property was taken, in addition to at gunpoint. Jesse Bukachian, he's the Riva employee who was at the counter, and he positively identified Dietrich Williams in a photo lineup in State's Composite Exhibit 10. If you'll recall, he's the one that at the counter was saying that he was selling a mask to Dietrich Williams, and he identified him as the person that he sold the mask to. And you can see that also on surveillance. Terry Yoakum, another Riva employee, he was the other one at the counter. He positively identifies Dietrich Williams in the photo lineup, and he even knew him personally and called him Chucky, or Tattoo Chucky, something to that effect. He identified also, this is important, Keith Graley. You'll recall, Keith Graley is the taller gentleman that was wearing camouflage at the counter, that was conversing with Dietrich Williams. And he identified them and remembered what they were talking about. And that it was recalled some conversation as being like lighthearted, talking about cars or motorbikes or whatever. Scott Barbeau. How can we forget Scott Barbeau? Scott Barbeau is one of the Riva Motorsports customers that was that was outside. He was eyewitness to the homicide. He described the shooter as the taller of the two gunmen, okay? And that's one of the things you can look at. Is the testimony and the evidence that you heard consistent with each other? Several witnesses all described the shooter as the taller of the gunmen. The taller of the gunmen is Michael Boatwright. And Layla Khan, who was with Scott.
No, I didn't.
She's another customer. She said that she was also eyewitness to the homicide. And she described the shooter as the taller of the gunman. That's more corroboration with the evidence. Marco Gruetta, who was also outside. He was the employee delivering the watercraft, if you recall. He was eyewitness to the homicide and described the shooter as the taller of the two gunmen. He also described yelling and that the victim was punched before the shooting. And this goes to the force, the violence. This was a violent event in order to take the victim's money and to kill him. Yeleni Delgado, after the victim was shot and killed and his money was stolen, she's the Just for Sports manager that helped Dietrich Williams pay for nearly $800 of merchandise that he bought the next morning within 24 hours after the homicide. She authenticated the Just for Sports surveillance video, which was State's Exhibit 19. She also authenticated the receipt, so you're able to see the date, the time. This is consistent with the surveillance video, which is State's Exhibit 20. And you can see the things that he purchased. Pay special attention to that, because it doesn't appear that it's someone that's just going shopping like any normal day, or look at all the different sizes that he bought, all the different things. It's almost like in a frenzy, like maybe it's not his own money, like maybe he just stole the money. A 4XL of this, shoe size 8.5, and then another shoe size, and it's almost like he's just buying out the store. as opposed to, maybe this is a common sense approach. When you go and you purchase things for your family or for yourself, would there be all these varying sizes? It wasn't even Christmas, this was June. You heard from records custodians, Ricardo Leal, who entered the records, cell phone records of all 3 co-defendants. Alex Fife, who entered the full surveillance, and that's important because you have 2 pieces of evidence, what we call the best of, which is the highlighted reel from Reba, but you can also, if you wanted to, go back and look at the full surveillance. And that's important because on the full surveillance, remember we pulled it up from State Exhibit 49, we see Keith Grayley leaving. And that's important because Keith Grayley was not the shooter in this case. He actually left in a white Civic before the defendants were even lying in wait for the victim. And that's on the full surveillance. Doris Paschel, she's the apartment manager that entered the full surveillance from Driftwood, which was State's Exhibit 7. We also heard from Tanisha Clark. She did not know the parties, but she was the Dodge Journey owner and rented the Dodge Journey to Tony Robinson the night before the homicide.
That'd be a
She rented it and
serious step up.
positively ID'd Tony Robinson in a State's Exhibit 15 in a photo lineup. She positively identified Michael Boatwright. And remember, this is important because she was given 2 lineups. This was a fluid investigation. At the point where they weren't sure who all the suspects were, they were receiving names. They received the name of Will Boat or Boatwright, something to that effect. So they pulled a photo lineup of 2 Boatwrights, Ronald Boatwright and Michael Boatwright. And this is important because Tanisha Clark, consistent with the other testimony that and the other evidence that you heard, identifies the correct Boatwright. Okay, so this is not something that should be considered as doubtful on her part. It should actually be considered as positive evidence of and beyond reasonable doubt that she identified the right person in this case. You also heard from Tony Robinson. She originally identified herself as Dietrich Williams' sister or cousin or something that night, but she's essentially told you guys she's his close friend. And she identified Dietrich Williams in court as the person who she rented the vehicle for. She identified Trayvon Newsom. She identified Michael Boatwright. And she rented the Dodge Journey for Dietrich Williams, Michael Boatwright, and Robert Allen, another application of the principal theory, where the 3 of them are utilizing someone to accomplish getting the car rented. And before I move on, think about this. The renting of the car, and this is a common sense approach, what purpose was that for? It wasn't to go to Disney World. It wasn't to hitch a trailer to it so that they can go motorbike riding. Because as you heard, there's some testimony that Dietrich Williams liked to ride bikes. There were no motorbikes that day. Instead, the 4 of them are together in this car that was rented for 1 day and 1 day only, not for a trip. They remained in Broward County, armed with firearms and masks. And it's just as you were told during the testimony that it was to rob people that day. You heard from Detective Marshall Wolcott. He was one of the crime scene detectives. He took into evidence the removed projectile, it was a partial projectile, which is States 37, from the victim at the hospital. He also entered the projectiles that were collected from the victim, from Dr. Boyko, collected 2 projectiles from the victim at autopsy, which was entered into evidence as States 67. The victim's necklace with observable blood on it. And you're gonna be able to take these things back with you to the deliberation room. It's in plastic because it's biohazard, but you can see, I know there was some testimony back and forth about, well, can you see blood? There's blood on it. You can still see it 5 years later. States Exhibit 38. He also collected buccal swabs from numerous witnesses, fingerprints, the cloth mask, which was important to this case, is States Exhibit 44. The neoprene mask, States Exhibit 55. The swabs of the mask, which were later tested by Nicole Hyman, States Exhibit 48. This is important, the blue book bag that was in a Cadillac in front of Michael Boatwright's home. Now, I submit to you that it was hidden. It's in an inoperable car, shoved behind things near a wheel well. And within that book bag, which was States Exhibit 43, within this book bag, you have 3 boxes of 22 caliber Avila brand ammo. You have the mask. You have items that were almost like a kit to rob people, hidden in the Cadillac in front of Michael Boatwright's home. In that, which is important, we're gonna talk about in a second, 3 boxes of 22 caliber of Gila brand ammunition, which was entered as State's Exhibit 46. And you'll recall, it's displayed for you like this. Okay, we'll talk about this in a second. And Tennille Carter. She identified herself originally as Tennille Williams because she was engaged to Dietrich Williams. She's his ex-girlfriend. And it's nothing, I know the saying goes, there's no woman like a woman scorned or something like that. She's not scorned. You can tell that even after they were broken up, she still tried to help, because remember, her testimony was that Dietrich Williams tried to get her to change or adjust her testimony to help him out by saying he was not the driver of the car. She positively identified Dietrich Williams in court. She identified Michael Boatwright in court and in the photo lineup, which is State's Exhibit 13. She identified Trayvon Newsom in court and in the photo lineup, which is State's Exhibit 14. She identified Robert Allen, State's Exhibit 12. And she testified how they were frequently together. And she didn't try to oversell her testimony. She didn't say that they were all best friends and that they were hanging out every day. She told you. She said, you know, I saw Trayvon Newsom, not as much as I saw the others, but Michael Boatwright and Robert Allen and Dietrich Williams were together. Pardon the pun, thick as thieves, okay? She also told you how Dietrich Williams persuaded her to write Judge Usan to state that he was not the driver. And think about that. Who does that benefit? It benefits Dietrich Williams. If there's something out there or an affidavit that says that he's not the driver. And she detailed how Dietrich Williams told her that he was there. And that's, you'll recall, one of the 2 times that Dietrich Williams is telling someone, because the other time is Detective Curcio, that he was at Reba during the homicide. And she also detailed that he witnessed the homicide and the robbery. He said that there were 3 people that were involved, okay? And this is important because this is close to the time that Mr. Envoy was killed. It's not 5 years later. It's not, he didn't tell her that there were rappers involved and that there was some conspiracy theory. He tells her 3 people were involved. He was there, and he was there at the time of the homicide. And what do we see from the surveillance? And that we know, and I'll get into that a little later. We know he was there because his phone was in there as well. We know he was there because we see it on surveillance. We see him there. Detective Clint Williams. He's a lead crime scene investigator. The crime scene photos were introduced through him. DNA swabs. This is important. 2 fired casings from the crime scene, State's Exhibit 30. If you recall, those were the ones that were right by Mr. Envoy's BMW that were collected. Cell phones from Dietrich Williams' residence, which were later, we later did analysis on. And this is very important. A live 22 caliber, single 22 caliber live bullet from Dietrich Williams' master bedroom, State's Exhibit 29. He collected latent fingerprints. The victim's jean jacket, State's Exhibit 34. The sweatshirt. Which is State's Exhibit 35. And this is important because this is consistent with the other evidence that as Mr. Envoy was seated in the front seat, the defects in the sweatshirt are showing that he was shot in his neck 3 times. State's Exhibit 34, also consistent with the defects in the clothing and the testimony that we heard from the medical examiner that Mr. Envoy was wearing his clothing, and the defects are consistent with him being seated in the driver's seat and being shot in the neck. These are all things, if you recall, when Dr. Boyko was on the stand, and I stood right here and he was pointing out where the actual injuries were. Remember, injury A, B, and C, those are all consistent. And these are things as you're evaluating the evidence, does the testimony and the evidence agree with each other? Is it consistent with each other? These are things that you can look at and take into consideration. Detective Williams also was, he also had evidence from the autopsy that was submitted to the lab. Detective Walter Foster, he executed the search warrant at Dietrich Williams' home. The orange slides with the socks, those were taken into evidence. And these orange slides We've seen these a number of times on Dietrich Williams and surveillance, not only at Riva Motorsports, but again, the next day at Just for Sports. Seems to be his favorite slide. Dietrich Williams' cell phone, States Exhibit 55, which was analyzed. Buccal swabs. The camouflage hat with red brim, the infamous camouflage hat with red brim, that we see over and over and over again on Michael Boatwright and all of the dozen or so videos that he posted after the homicide, wearing this, if you recall, a black champion or something to that effect hat or a shirt. Videos downloaded from Dietrich Williams' cell phone. The Riva receipt for the mask purchase. Dietrich Williams' social media pictures were also entered into evidence. Detective John Curcio, he's the lead detective. He also re-entered in through head of Michael Boatwright's cell phone, States Exhibit 63. DNA swabs. And you'll recall, he interviewed Dietrich Williams. Dietrich Williams denied at first being at Riva and said that he wasn't even there. He gave 3 different versions. He then said, okay, fine, I was at Riva with my kids. Also a lie. Okay, fine, I was there during the homicide, which is what he also told Tanel Carter. And you recall, through Detective Curcio, we learned that Dietrich Williams changed his story 3 times. And this is immediately after the homicide. No evidence or statements about any rappers involved, anybody from another country, rap beefs, Twitter beefs, nothing. He talked about him and 3 people being at Riva. He lied repeatedly, and you can take that into consideration as a consciousness of guilt. Is he trying to show that he wasn't there to minimize himself, like when he's trying to get Tanel Carter to change her testimony? And again, he never mentions any rappers, any rap beef as being part of this homicide. Detective Curcio also executed a search warrant at Trayvon Newsom's residence because of a text message and evidence linking Trayvon Newsom to the co-defendants. And you'll recall, it was in John Curcio's testimony that he said that the text message read, "I buried it at my house, and I get you pregnant and stay out here, and soon gone, have to dig up the money. I got the 8,000 buried. Real shit. I be thinking I'm gonna catch life, but I bury that bitch." What could he be referring to? Maybe it could be the money that he was posing with within 24 hours after the homicide that we'll see out of Michael Boatwright's phone, saying that he's catching life, saying that he got snitched on. And that phrase is important. You know why? Because we learned in this very trial, Trayvon Newsom, out of all 3 co-defendants, had the nerve and the gumption to threaten a witness that's testifying, while the witness is still under oath and testifying for you during the days that he was here. And just like he says in that text message about somebody snitching on him, what does he do? As soon as he can get within earshot with that witness, he calls him a bitch. He calls him a snitch. He says that he's working for the white man and that he's working with the popo. That's consistent with the testimony that you heard from Trayvon Newsom, or about Trayvon Newsom. Nicole Einert was the DNA analyst who she analyzed swabs. Remember, we talked about the unknowns and the knowns. And the neoprene mask, the swab of the neoprene mask, which was states 45, and the swabs are from states 48, she identified that. Remember the numbers, it was like 1,000, a million, and all the way up to octillion identified to Dietrich Williams. DNA on the swab of the black cloth mask, I think that was not octillion, something, a number that was even more zeros added, identified to Michael Boatwright. And you'll recall, this is important because I know that there was testimony that at least one of the co-defendants was an avid bike rider, okay? And you saw testimony, or you saw evidence that was entered as a defense exhibit. I believe it was Michael Boatwright's defense exhibit of Michael Boatwright with a mask. But that day, you'll recall, think about the other evidence that you heard in the common sense approach. Dietrich Williams and Michael Boatwright were put at the scene of the homicide, during the homicide, by the location data of their phone. They weren't bike riding. They weren't at work tattooing. Michael Boatwright wasn't at work doing landscaping or whatever it was that he was doing at the time. They were at Riva Motorsports committing this armed robbery and homicide. That's the significance of that evidence. The DNA swabs, you'll recall, she identified two Genesis Sanchez from the victim's car and from the victim's fingernails.
I'll object to that, not letting it go.
Jury will rely on its own recollection of testimony you received.
DNA swabs from inside the Dodge Journey, the AC control, she identified it to Robert Allen. And she did say to you, she didn't try to oversell her testimony, that there was no DNA on the necklace or the victim's neck.
Objection.
Overruled. Jury will rely on its own recollection.
However, there was no foreign DNA on the victim's neck and the necklace. And so consider
Overruled.
consider this. There's going to be a lot of argument as to whether or not you can find the defendants guilty of first-degree murder and armed robbery because of the absence of DNA on the victim's neck. But there aren't, if not them, then who? Because there isn't any DNA. And so remember, I touch this podium, I actually touch it a lot as something that I do when I walk around and I'm talking. And I asked Ms. Iman, if I'm touching this podium, is there any guarantee that there's going to be DNA that's detectable from me touching it? It doesn't mean that I didn't touch it if you don't find my DNA there. That's not what that means. And so when you're thinking about this evidence, consider it not as this like smoking gun that's like, oh my gosh, these defendants are not guilty because there's no DNA on the defendant's or the victim's neck. It should be considered with all other evidence because there's a lot of other very compelling evidence that does prove their guilt. And
Yeah, like a
that's
video of
DNA
the freaking
does not
crime.
mean that Trayvon Newsom wasn't grabbing at the victim. It doesn't mean that Michael Boatwright wasn't punching the victim or shot the victim. So consider that as you're evaluating the evidence. And you'll recall that she said the absence of DNA does not mean you didn't touch something. The identity of the victim was only stipulated by one co-defendant, and the stipulation was read by Judge Uson. That was
Object to that, we should close that one.
by Mr. Envoy as a person in State's Exhibit 69. And that exhibit was important because it had the placard identifying from the medical examiner's office, which was also linked to the testimony for Dr. Boyko. So I would submit to you, under the elements, when we talk about, remember, element 1 of all the homicide counts is Jose Envoy is dead. That is how the state was able to prove that particular element. And it's the first element in all of the homicide counts. You also heard from Dr. Yuri Boyko, who is an associate medical examiner. He performed the autopsy in this case. He retrieved 2 fired projectiles from the victim. And this is important because he talked about there were three wounds. One where the projectile went through, so it wasn't recovered at autopsy.
Yeah.
And then the 2 that he recovered, and he talked about the wound path.
One of my New Year's resolutions to learn law this year.
He talked to you about the victim being shot, where the victim was shot 3 times in the left part of the neck, which is consistent with all the testimony that you've heard, not only from the defects in the clothing, the eyewitness testimony saying that the gunman, the taller gunman, Michael Boatwright, was the one that shot the victim in this case from the driver's side of the vehicle. And Dr. Boyko testified that because the victim was shot on scene, but then transported to the hospital and was receiving life-saving measures from the hospital emergency doctors, that he had to be sanitized for surgery. And so you can consider that as a way that potentially it could affect the collection of DNA, because he told you that ethanol and things like that are used to sanitize the surgery room, the instruments, and the patient. And he told you that the cause of death was multiple gunshot wounds and the manner of death was homicide. You heard from Jim Campbell, who was the last witness that the state put on. He was a digital forensic unit supervisor. He analyzed Dietrich Williams' cell phone, Michael Boatwright's cell phone, and he testified about the location data, photos, and videos found in the cell phones. And that's important because out of all of these visit locations in Michael Boatwright's phone, and remember it's in evidence, by the way, Mr. Campani's PowerPoint. So this is only to highlight. So if you need to see something a little bit more detailed, you're welcome. You can take it back and look at it. But notice out of all the stops that are there, it's important to note there are no stops from
It's funny,
Mr.
but it's
Williams' home
ridiculous.
and Reva to either pick up or drop off Trayvon Newsom. No stops at his home. And so I would submit to you, the common sense approach to that fact, Trayvon Newsom was with Dietrich Williams, Robert Allen, and Michael Boatwright the entire time. And we'll get into how we know that, but consider that as you're looking at the location data from Michael Boatwright's phone. Also, the location data from Williams's phone. Again, no locations that would be obvious picking up or dropping off Trayvon Newsom. And so like to the testimony you heard, he was with them the entire time. These are the movements from Michael Boatwright and Trayvon Newsom, or excuse me, Michael Boatwright and Dietrich Williams' cell phone.
She's doing great, but this is a long closing argument. Of course, they have 3 defendants.
I promise you it worked. And so this particular exhibit, by the way, is an evidence. And you'll recall that the movements were together in unison from Reba Motorsports, or excuse me, from Dietrich Williams' home to Reba Motorsports and then back down to Allen's home. At no point in time were there any stops to Trayvon Newsom's home, which would be obvious either as a pickup or a drop off. And so again, when we talk about putting together the evidence and thinking about it and deliberating it in a common sense approach, that I would submit to you that they were together. And the location data, which is important, from 3:30 to 3:56, Mr. Campani testified, and this is during the time of the homicide. When you see the taller gunman who's pointing, I submit to you the 22 caliber rifle, and we know that because remember, right here is where the casings end up. And that's Michael Boatwright,
Thank you, Amy.
and that is Trayvon Newsom, because there's no stops, obvious stops, dropping off or picking up Trayvon Newsom.
That would
And
be
that
great.
car driving is Dietrich Williams, and in the backseat is Robert Allen. And the location data from Michael Boatwright and Dietrich Williams' phone tells us that that's him. Not only because of location data, but you'll recall his phone was connected to the Bluetooth of the car the entire time of the homicide. And in order for your phone to be disconnected, this is common sense. You walk away far enough, your phone disconnects and then connects to the next Wi-Fi connection. But look at how close he is to the car. Close enough that his phone is connected the entire time while the victim is being gunned down and robbed. I might have to have Ms. Buckle assist because these were working earlier, I promise. This is just like a trial, remember when we had all the technical difficulties? So I'm reminding you of that as well. what I may ask for is a brief comfort break while we get this to work, because it was working earlier, so.
Do that.
Absolutely.
Ladies and gentlemen, why don't we go ahead and take about 5 minutes?
How to see it on YouTube? Every sense of the word.
Parties may be seated. Court will come to order. Parties are present. There is a president and one backstage.
All right, ladies and gentlemen, thank you, Judge. After this brief technology break, I hope that you were able to use the bathroom. I'll call it an intermission. I think we got the technology working. So one of the things that we were last talking about was that the location data from Michael Boatwright and Dietrich Williams' movements from 117 to 520, and that's important because
Of course.
not only does it include the time of the homicide, but it's a big window because it shows how long they were together. So when you think about principals and how they assisted each other, and remember, there are no obvious stops, picking up or dropping off Trayvon Newsom, and we'll get into how we can prove that he obviously was with them the entire time. Look at this location.
Thank you.
Okay.
All right, we're 2 hours back. If they take a long,
The animation that
you
Mr.
can catch up.
Campani put together with location data from Cellhawk program, where it shows the phone in purple is Mr. Williams's phone, together with the phone that's notated in red as Mr. Boatwright's phone, the entire time they're together. And think about the other testimony that you've heard. Mr. Boatwright's phone is connected to the Dodge Bluetooth the entire time.
Yeah, that's a thing of beauty. It really is. Thank you all. Well, hi, Lori.
And there they are, traveling to Reba Motorsports where the homicide occurred, remaining stationary during that entire time that you see the car on surveillance. And I would submit to you committing the homicide during this time. And this is important because you don't see the phones separate, which shows that they were together. You don't see Mr. Boatwright's phone at some other location like his grandmother's house. You see him at Reba Motorsports the entire time during the homicide. And consistent with the other testimony that you've heard, you see the phones arrive at Mr. Allen's home, just like the testimony that you've heard that they all went to Mr. Allen's home to divvy up the $50,000 that they just stole from the victim after they killed him. And here they are arriving at Mr. Allen's home where they remain. And notice, when they left the homicide location, there were no stops in between. And we know at Mr. Allen's home, who's with them? Trayvon Newsom. Because Trayvon Newsom, you'll see, appears on surveillance with Michael Boatwright. And look at how long they are at Mr. Allen's home. Think about how long it takes to count and separate $50,000 amongst 4 people. And how do we know they had that cash? Because we're gonna see the evidence, how they all bragged about having the victim's stolen cash afterwards. This is also the time where, I submit to you, you're getting rid of the firearms. Remember, they were never recovered.
Yes, you have an entire thing called trial advocacy, and you learn all about how to handle a trial. And within that, you learn how to,
And while we see Michael Boatwright stay at Mr. Allen's home,
you know,
consistent
speak
with
to
the
a jury.
testimony you heard, there goes Mr. Williams leaving. Now, could have been by Uber, whether he called somebody to have the Uber call for him, we don't know. Mr. Campani didn't oversell his testimony. He said it could have been one of those unknown numbers. But what we know is the location data is consistent with the testimony that Mr. Williams leaves the 3 of them there and then returns back to his house. And so during the most important time, which is the time of the homicide, the location data does show that the 2 defendants' cell phones, which I submit to you was in their possession and in their hands the entire time, shows them at the homicide location, consistent with the surveillance. And we know this because as we see the location data showing them arriving at Reba,
I guess this is important because they want to
we also
corroborate
see
the
the
video
Dodge Journey,
because the
which is
guys had masks
connected
on.
to Michael Boatwright's
I
Bluetooth,
see why they're doing it.
arriving at the exact same time. And we know that the phone was in Dietrich Williams' hands because very shortly, you're gonna see him get out of the car and go inside with those very same orange slides that are in evidence, where he's then seen in the Reba Motorsports inside the store, scoping out the scenario to tell the others that they spotted the victim inside. We also know that during that entire time, also connected to the Bluetooth again, Michael Boatwright's phone, the entire time connected to that Bluetooth, it matches with a departure from Reba at the same time. And so that's important because they didn't get out the car when there was a sedan that stopped in front of the car while they were lying in wait. They didn't get out the car when there was a car backed up next to it, if you recall. They're in that van, lying in wait to rob and kill the victim.
Thank you.
And just like the location data shows, they're departing at 3:56, consistent with the surveillance, showing them leave immediately after the homicide. Consistent with the location data, here they are arriving at Robert Allen's home. If you recall, that's the exact track that the location data shows. And what do we see on surveillance from the exhibit from Driftwood Apartments? There it is, the Dodge Journey connected to Michael Boatwright's Bluetooth. He's in that car, ladies and gentlemen. That's the common sense approach. His phone isn't traveling in the car by itself. It's in his hand. He's in that car, connected to the Bluetooth with Robert Allen and Trayvon Newsom and Dietrich Williams. And there's the Bluetooth connectivity that Mr. Campani told you about. Michael Boatwright's phone. The connection started at 3:25 p.m., just before the homicide. It doesn't disconnect until 4:28. That's the exact time of the homicide. You also heard from firearms analyst William Ruiz Fontanez, who analyzed the 3 boxes of the .22 caliber Aguila brand ammo that was found in Michael Boatwright's home, hidden in that backpack in the inoperable Cadillac. and that states Exhibit 46, is consistent with the caliber and the brand as states 67, states 29, states 30, and states 37. And Mr. Ruiz Fontes compared and analyzed the two projectiles that were recovered from the victim at autopsy, which is state 67. He also compared, which is important, the live 22 caliber, that single bullet that was, I submit to you, kept as a trophy or whatever, that was at Dietrich Williams' home. Okay? And this is how, when we talk about principal theory, look at all the evidence that connects them. 22 live at Dietrich Williams' home. The 3 boxes of 22 caliber Aguila at Michael Boatwright's home. The 2 fired projectiles from the victim, analyzed and compared also from the fired casings that were on scene. And it's concluded that those exhibits, 67, 29, and 30, were cycled through and fired from the same firearm. That's important, ladies and gentlemen, and I can't underscore this point enough, because that means that evidence from Dietrich Williams' home, the fired casings that were found near the victim's car, and the fired projectiles are from the same murder weapon. And so even though the defendants tried to get rid of the firearm to try to avoid detection, what they left behind still connects them to the homicide, because all of that evidence was cycled through the same firearm. That's the importance of what was left behind. And there's something else to note. The 3 boxes of 22 Aguila brand ammo from Michael Boatwright's home, which is states Exhibit 46. If you'll recall, there's supposed to be 40 in each box. You can count them. You can take this back with you. You know how many's missing? 4. Only 4. And the only 4 that are missing, 1 is the partial that was taken from the victim at the hospital when there were life-saving measures, which is states 37. That's one of the missing ones. The other is a fired projectile recovered from the victim at autopsy. That's the second missing bullet. The third is the fired 22 caliber projectile recovered from the victim's body at autopsy. Remember, there were 2. And then the live bullet recovered from Dietrich Williams' home. So there's 2 projectiles recovered from the victim, a partial that came from the victim, and then the 4th was at Dietrich Williams' home. And all this evidence is connected to Michael Boatwright's home. Only missing 4. That's not a coincidence. That's not a guess. You can count them. 2 plus 2 equals 4. Let's talk about, because I know I've talked a lot about, for example, robbery and felony murder, but you can find still that these defendants, if you choose to find that they were guilty of premeditated murder. Let's talk about premeditation. Premeditation is killing with after consciously deciding to do so. The decision must be present in the mind at the time of the killing. And the law does not fix the exact period of time that must pass between the formation of that thought and which is the premeditated intent to kill, and the actual killing. So it doesn't have to be weeks. It doesn't have to be months. It can be you form the thought and you do it. It can be you jump out the car, you point a rifle at someone, and that thought is formed, and you shoot and you pull the trigger and you kill them. That could be your premeditation. And so in this case, I actually have more than just a moment of premeditation. 8 minutes, 35 seconds. So 8:35:61 is the exact amount of time that the defendants were lying in wait. You remember, after Dietrich Williams and Robert Allen come from inside Reba and they confirm Triple X is inside, and they go with all 4 of them are now in the Dodge Journey. You remember, you heard testimony. They all went in the car and then they parked across the street from the vantage point to be able to see the victim's BMW i8 and wait for him. And they waited for him for 8 minutes, over 8 minutes, almost 9. And so if I say to you, 8 minutes, it could mean anything. We use that time frame. I'll be there in 10 minutes, like it's nothing. But 8 minutes, when you're waiting to take someone's life and by force shove a gun in their face, is an eternity. So let's see how long 8 minutes feels in 35 seconds.
She's not going to go the full 8 here. Take you about 30 seconds to make the point. I mean, she's really going to stand there. I get it. She's got premeditation locked. I don't know why she even needs to do this. It's an effective. It's a good thing, and she's excellent. But she's anticipating an argument she knows they're going to make, but it's a grasping at straws argument on the defense anyway.
It wasn't going to be Dietrich Williams because Dietrich Williams was the driver. And so during that 8 minutes and 35 seconds.
Okay, I cheated.
He's putting on his mask. Trayvon Newsom is putting on his mask. They're covering their heads with hoodies.
Well, that is the
Making
point.
sure that the firearm is loaded. The .22 caliber rifle. The handgun in your testimony that Trayvon Newsom had in his hand.
It does.
And they're waiting for that whole time. And during that time of eternity, Mr. Onfroy is inside Reba, doesn't have a clue that any of this is about to happen, that he only has 8 minutes and 35 seconds left to live. And so while he's in there with his own money, trying to purchase a motorcycle, and he comes out with Leonard Kirk, that 8-minute clock is still ticking as they're waiting. Almost like predators, just waiting for their victim to come out. And as he's walking out and they spot him, the car's on, in drive, ready for Dietrich Williams to punch on the gas and immediately cut the victim off as he's trying to exit the parking lot.
That's my only problem with that stunt.
That coordination of as soon as
It's wasting the jury's time.
The victim's car. The two passengers
Other than that, I think it's
slide away.
effective.
And what do? They jump out with their firearms that they know are loaded and ready to go and ready to fire. And each one goes on the side of the car to rob and to kill the victim. And I submit to you that that is more than enough time for premeditation. You don't have to take my word for it. You can see it for yourself.
Absolutely not. We've got lives to lead. I'm going to pretend not to understand your implication. It's always dirty here.
That evidence, ladies and gentlemen, is evidence of both premeditation and felony murder. You also heard from Deputy Alvarez, who took the stand and testified that he escorted Robert Allen to court. We made no bones about it. Robert Allen was in custody. Robert Allen came with his own host of baggage, right? But while he was being escorted to court, Trayvon Newsom, and you'll recall Robert Allen testified about it, but it was also corroborated by Deputy Alvarez, pointed out Trayvon Newsom as the one defendant who intimidated Robert Allen. Think about the nerve that it takes to be able, while somebody's with a BSO deputy, to threaten that person in the deputy's presence. Think about that for a minute. And that's not somebody's discontent because, hey, my friend is testifying against me. No. The common sense is he's on trial for first-degree murder. And just like the text message says that he was snitched on, he is pissed that Robert Allen came in front of you and is testifying and pointed him out as the gunman. And so even though in court he's wearing a three-piece suit and he's quiet and demure, as soon as he gets the opportunity, what does he do? He starts yelling at Robert Allen without any provocation, calling him a bitch, saying that he's working for the popo. He's working for the white man. And he's positively identified as the person who did it. Why would somebody do that? Why? It is called consciousness of guilt. Because if you know that you murdered someone and you're on trial for that murder, you're not going to say to the person, oh, you know what? I'm upset because we used to be friends and I stayed at your house. He didn't say, why don't you tell him who really did it, Robert? What does he say? You're a snitch. He calls him a bitch, yelling all the way till he can't see Robert Allen anymore. That's consciousness of guilt. Trayvon Newsom's guilt.
Sure
The other
is.
things that you can look for Trayvon Newsom's guilt, remember, he's the one that got a ticket for the crash that happened in Fort Lauderdale. Irrefutable that he was with the co-defendants that day, because it's been said over and over, even by his own attorney through questions. He willingly went back, he said, to the crime scene of the crash scene, and that he gave up his license as the person who was driving, even though he wasn't driving, by the way. He was in the car, but he went back to the crash scene. And he's seen on surveillance just before the crash. Remember, there's Trayvon Newsom and Michael Boatwright parking the car backwards, and when they were trying to avoid having the car in front of Robert Allen's home. That's another thing you can ask yourself.
Closing covers the whole deal.
If either of them are innocent of this homicide, why are they parking the getaway vehicle way down the block where nobody lives there? They're not with Dietrich Williams. They're not with Robert Allen. They're by themselves. They're two of the four killers. Why would they be doing that? He's with Michael Boatwright at the crash. And remember, Michael Boatwright's phone the entire time was connected to the Bluetooth. And there's no stops made between Riva Crash and Lauderhill, where the crash occurred. Reasonable and common sense approaches to conclude that Trayvon Newsom was with Dietrich Williams, Michael Boatwright, and Robert Allen, and is the second gunman. And Trayvon Newsom, remember, he doesn't have a job, but as we'll see, he just happens to have thousands of dollars in cash the day of the homicide. And Trayvon Newsom made the statement in the text message, or the text message says that he was going to bury $8,000 in the backyard. And last but not least, he's the one out of all of the defendants that threatens Robert Allen during the trial. This trial, when Robert Allen is testifying to you, Trayvon Newsom has the nerve and the audacity to threaten him, to try to get him, to intimidate him so he won't testify in front of you. He did that. And then, of course, there's all the videos from all of them, mind you. When we talk about how they work together, the first 4 videos are from Michael Boatwright's phone. Okay? And this is from Dietrich Williams' phone. But when we talk about how the evidence, you can view it together, look at this. The next 2 videos, pay attention and listen to the music, how it's a continuously one
Absolutely.
song in the video.
And I think that's what's interesting. Wow, man, I don't want music. I can talk over this music.
And besides paying attention to that, you see the hat he's wearing in the video? Same hat? Different than the hat that Keith Gray wore?
Stop with music.
So it stands to reason. See the vantage point?
It's garbage, too.
Michael Boatwright appears to be in a car, seated in a front seat. Somebody's taking that video for him. So I submit to you, that's Trayvon Newsom videoing him as Michael Boatwright shows off the victim's stolen money. And then Trayvon Newsom, just like Robert Allen told you, then passes Michael Boatwright's phone, because he used his phone. And then now he videos. Same music.
Really does. Go away.
You can hear it with your own ears. And you can see they appear to be in the same car. And this is also important because Jim Campani testified about the metadata from each of these videos and put the location of each of these videos. And so, again, when Michael Boatwright was taking this video, the phone was in his hand. He never left. The phone didn't separate from his hand. It's his phone, not a community phone. Look who's with him.
Thank you, Iris.
Trayvon Newsom. And the location data puts them together because obviously they're together from the same song. And pay attention also to what they're wearing. And not to be left out of showing off the victim's money is Dietrich Williams. That's who they really are. Not the defendant that wears a bow tie to court at his trial, or the defendant that has a three-piece suit, or the defendant wearing a turtleneck in front of you, sitting here quietly.
Did she just say
This is
creepy
who they
suit?
This is their real character. This is who they are.
Oh, Jack's comment about the character and property.
It truly is.
This is their character. Killers that within 24 hours after shooting the victim dead and stealing $50,000 from him, this is what they do. Look at how happy they look.
That makes more sense.
Look at how excited they look to have this money as they're showing it off repeatedly. And I didn't even put all the videos in this slide. You have it evidence. It's dozens of videos. Look at his face, how happy he looks. It's okay, you can look at him. You see him there now. This is who he is. And I submit to you, this is real money. It's common sense, it's real money. Look at it, how crisp it looks. Like it just came from a Bank of America, dispensed earlier that morning. Look at how the bills are all facing each other. As if Cecilia Ramos had just run it through the counter. And all of the bills happen to be facing the same way and folded in the same way. Those are things that you can take into account as you're looking at and considering, was this really what they did? I submit to you, it absolutely 1000% is what they did. The other thing to pay attention to with these videos, you'll recall the Driftwood surveillance shows, and this is something that defense counsel, or for example, Mr. Newsom admitted as much. He says that he was in the car after the fact because of the crash ticket. And so the surveillance video shows two people. Shows two people leaving the Dodge Journey just after the homicide. And again, remember I was saying to you, Michael Boatwright and Trayvon Newsom were together the entire time. No obvious stops that Trayvon Newsom was picked up or dropped off. And so here they are, taking the suspect vehicle, parking it way up the street for no other reason other than they just committed a homicide in that car and they don't want it to be detected in front of Robert Allen's home. And what do we see them? As Trayvon Newsom is, look at what they're wearing. Look at what they're wearing. Look at the height difference. Trayvon Newsom in the white t-shirt, just like he is here, flashing the money. Here and here. Same ripped jeans. Same hat. Same black shirt Michael Boatwright has on there with the champion logo that you can see, even from the vantage point right there. It's the same. And this evidence, by the way, when we talk about does the testimony and the evidence agree with each other, this is what Robert Allen testified about. He said that this is what they did. You don't have to take his word for it. You can see it on the surveillance from Driftwood. And you can see it consistent with videos from Michael Boatwright's phone. There they are. She says from here to here, something happened. You will get an opportunity. I'm going to talk to you again. I'm going to be talking to you before I sit down about what you'll get when you're in the back deliberating. Okay, so besides the evidence that you're going to get to review and talk amongst yourselves, you're going to get verdict forms, and this is what they look like. You're going to get one verdict form per defendant per count. So that's 2 verdict forms, 6 total for each defendant. Okay, and so it looks just like this. The pertinent parts. The first one is for count 1. And remember, the state is asking you to vote guilty for the highest count charge, which is first-degree murder. You're going to get the options like we talked about the lessers. It's going to be on the verdict form here as B and C. But based on the evidence that has been presented to you, I submit to you that the state has met its burden as to each element beyond and to the exclusion of all reasonable doubt that the defendant, Dietrich Williams, is guilty of first-degree murder. And so remember, during jury selection, I actually asked row by row. Each row, I asked, if the state presented all the evidence and met its burden, could you vote guilty of first-degree murder? It wasn't a question that was just in futility or hypothetical. This is now real. The state is asking you to vote guilty of first-degree murder. And I asked you at jury selection if you could do that, because now is the time that we presented the evidence to you, proving to you that Dietrich Williams is guilty of first-degree murder. And now is the time when you go back there and deliberate, you're going to see this verdict form. I'm asking for you to check that box that he's guilty. You will also get a verdict form for count 2 for armed robbery. You're going to get all the options that we talked about, the lesser included offenses. But I'm asking you to vote the highest offense charged in the indictment, which is guilty of armed robbery, because that's what we've proven. Trayvon Newsom, you'll get a verdict form for him for count 1. His is going to look a little slightly different. It's going to have all the options for first-degree murder and the lessers, but you'll also have a question at the end. And so, just the same, we're asking you to vote guilty, that Trayvon Newsom is guilty of first-degree murder, which is the first option, so you check that option. But then you'll also get the opportunity to ask yourselves, during the course of the crime committed, did Trayvon Newsom actually possess a firearm? That's a question of fact for you to consider, and I submit to you, the answer is yes. Not only did you hear testimony that he had a revolver, but also it makes common sense. You're not going to jump out of a car to commit a robbery with a weapon in your hand. That's a common sense approach as well. And so consistent with testimony and what you've seen is that he had the firearm in his hand. And that's what you heard from all of the witnesses, eyewitnesses, by the way. They said that the second person, the shorter of the 2, also had a firearm in their hand. And so I submit to you that you can check that box as yes, that he also had a firearm in his hand. Now, for count 2, I submit to you that Trayvon Newsom is also guilty of armed robbery. And so we're asking you to check the first option, which is guilty of armed robbery. And also during the course of the crime committed, to answer this question, yes, he actually possessed a firearm as well. So you're going to answer that question twice, for count 1 and for count 2. You'll then get the opportunity to fill out Michael Boatwright's verdict form, and his is going to look slightly different from the other 2. First, we're asking you to vote that he's guilty of first-degree murder as charged in the indictment, because that's the highest crime charge, and I submit to you we've proven it by all the evidence so far that we talked about. So to check that option as guilty. Then, during the course of the crime committed, did Michael Boatwright actually possess a firearm? There's going to be 3 questions for you to answer. 1, did he actually possess it? Yes. That's what the testimony shows. That's what the evidence shows, the surveillance. Also, circumstantially, look at all the ammo he had matching to the actual firearm. There's testimony putting him as the shooter by Robert Allen is corroborated by all the eyewitness testimony saying that the taller of the 2, of all of the co-defendants, was the gunman that shot the victim. So he possessed that firearm. Did he discharge that firearm? Yes. There's 4 missing ammo from that box that was found in front of his home, all connected to the firearm, all connected, which is the murder weapon in this case. And so the second question, I'm asking you to answer yes. The third question, during the course of the crime committed, did defendant Michael Boatwright actually inflict death on Jose Onfoy as a result of discharging that firearm? Yes. He's the shooter. I've made no bones about it from the beginning. He's the one that discharged that 22 caliber rifle. And everybody had said the tallest of the gunmen. I hope that you looked when we were on break. He's the tallest at all of them and has been identified as the shooter. And so it's his weapon that actually killed Jose Onfoy. You'll get an opportunity to deliberate as to the second verdict for Michael Boatwright. I ask that you also vote him guilty of armed robbery as charged in the indictment. Answering the same questions again. Did Michael Boatwright actually possess the firearm? Yes, for the reasons that we've stated. During the course of it, did he discharge that firearm? Yes. And third, yes, a resounding yes, that by the discharge of that firearm, that death was inflicted on Jose Onfoy. I think that when you are deliberating and you are able to review everything and think about the credibility of the witnesses, the quality of the evidence that you've seen, you're gonna go back there and you're gonna think about these final thoughts. This is as to Dietrich Williams. Not only was he a principal, he was the driver. Tanel Carter's testimony corroborates all of the other evidence identifying him. Robert Allen's testimony is also corroborated by all the other evidence you've heard. He tries to get Tanel Carter to change his testimony. Tells Tanel Carter that he was at Reba. He admits that to her. His DNA is on the mask, one of the two masks. He's flashing money immediately after the homicide. The live 22 from the murder weapon matches the fired projectiles from the victim and also matches the ammo found at Michael Boatwright's home. His post-Miranda interview with Detective Curcio, where he lies and changes his story 3 times. He lies about Reba first being there than saying he is. And his cell phone location data putting him on scene during all the pertinent times. That he's guilty. You're going to, I believe, I submit to you find that Dietrich Williams is guilty of first-degree murder and guilty of armed robbery. As to Trayvon Newsom, he's a principal. He's flashing money immediately after the homicide. His videos are found on his co-defendant's phone, placing him with them on the day of the homicide and during the homicide.
Yes.
The text message about burning the money. Robert Allen's testimony, putting him as the second gunman. Tanel Carter's testimony, when she identified him as being with the co-defendants during that time. He's the second gunman. Remember that consciousness of guilt. He's the only one that threatened a sworn witness that was in front of you. Surveillance footage places him with the co-defendants. The Driftwood surveillance footage. The threats to Robert Allen, the intimidation, and he's ticketed for the car crash that also puts him during that time. So he's also guilty of first-degree murder and of armed robbery. Michael Boatwright, he's the shooter. The 22 Aguila bullets match the fired projectiles from the victim's autopsy and the live 22 from his co-defendant's home. Tony Robinson's testimony as well puts him as picking up the car, you'll recall. He picks up the Dodge Journey with Robert Allen. Tanel Carter also identifies him as being with the co-defendants during this time. In addition to being a shooter, he's a principal as well to his co-defendants. His DNA is on the mask. All the evidence proves that he was a shooter and not at his grandmother's house gingerly sleeping. The fired casings on scene and the fired projectiles from the autopsy match the murder weapon. Robert Allen's testimony also is corroborated by all of this and puts him as a shooter. His location data places him on scene the entire time. His Bluetooth connectivity also has him on scene and connected there. He never left the homicide scene. He's also guilty of first-degree murder.
It's a good question. I honestly don't know. We'll find out.
Get a second opportunity to speak to you after all of the defense counsel has had an opportunity to talk to you. And I ask you to please, as you have been so gracious in paying attention to all the details that have been discussed and the evidence that's been presented to you, think about the things that we've talked about so far. I know I've been standing up here talking for a long time, but think about these things as you listen to the additional arguments and keep that common sense approach. And keep that in mind, that these defendants are guilty of the two offenses that we have charged them with. And I'll wrap up when I get that second opportunity to talk to you. Thank you, ladies and gentlemen.
Thank you, counsel. Ladies and gentlemen, it is 1:15. I think we can kind of take a break, clear your heads a little bit, relax, come back in 1 hour. Come back in 1 hour.
Oh, good Lord.
We'll have their opportunity to close
Now we have to go watch
again.
the Three Stooges.
Time to break. I'll remind you, you're not one of the other fixed meetings in your case, so you're all the evidence. The government is all subject to any questions or money. Will that not-
There's no helping it.
Of course, the trial will be ready. He says-
Let's go.
He is a young man wrongfully accused, kept his composure almost through this entire trial, except for one expression of anger that you heard about from the state, as if it was him confessing. Nothing could be further from the truth. I get one opportunity to speak. The state will have another opportunity.
Congratulations,
In order for me
Zach.
to respond properly to what they've said. in the
That's
court,
cool.
Let me start with some remarks about what the points they tried to make. Then I'll go into the closing argument I'm prepared to present to explain to you why the evidence does not show Trayvon Newsom should be convicted of these offenses. I congratulate the state on their slick PowerPoint presentation and on their argument. The argument is not evidence. Supposition, speculation, they're not evidence. Even asking you to use common sense when the evidence is weakest in the case is not evidence. You all, in jury selection, swore to follow the law. You told us that you would, we trusted that you would. And if you do, if you listen to the law the judge reads you, much of it you've already heard. And then look at what the state's evidence really is, not what their argument is,
Okay,
not what the possibilities of what they say are, but what their evidence
we're now
is or
about
doesn't.
40 minutes behind.
You'll find Trayvon Newsom innocent of these charges. The state told you that Trayvon needed assistance to rent the car because they want him included in a principal. What was the evidence? He wasn't even there when the car was rented. He had nothing to do with the rental of the car. That's what the evidence was. 2 photo lineups with his picture included. They failed to identify him, although they clearly saw who was there, and those witnesses knew. It wasn't Trayvon Newsom. So the state asks you to suppose that he needed help to rent the car to commit a crime, but no evidence supports it. In fact, contradicts it directly. The state says Trayvon threatened Robert Allen. Well, the testimony was he cursed at him. Not that he threatened him. Not in any way did he threaten him. He lost his cool. Deputy Alvarez was called by the state to back up the testimony of Robert Allen, because I'm sure the state realized at that point you can't believe anything Robert Allen said. So you might totally disregard the fact that he had an outburst, and they needed you to hear it from a deputy who came in and told the truth and said, I heard him string a bunch of curses together and call him a bitch, not a snitch. But remember how the state tried to take that word snitch and get the context of it in front of you. It means he's guilty of something, and this man is testifying against him. No, that's supposition. That's argument. That's not evidence. Angrily calling someone a bitch for accusing him of a crime he didn't commit is what I expect an innocent man to do, and what you should as well. And that's all you heard. In no way equates with consciousness of guilt, as the state suggests you it does.
Yeah, it does.
It could cut easily exactly the opposite. And other evidence in this case does. We'll talk about that. The state makes the point that the other 2 phones don't appear to stop in those PowerPoint presentation, so they had no time to drop off Trayvon. So he must have been with them the whole time. He wasn't with them at all. He didn't have to drop them off. And the evidence proves that. Made very light of by the state, but Detective Curcio told you that the phone evidence from Trayvon's phone showed a call a couple hours before this, and conspicuously a call at 4:02 p.m. in a totally different city. Detective Curcio's own testimony. Is he a magician that he somehow made it those many miles in 3 or 4 minutes after this crime to try to mislead the jury later on? No, he was never there. His day intersected with them later. And then you see, he did some stupid things. He posed with some money, which may or may not have been money he knew was taken from that robber. But the point is, if he's not a principal in the first degree to it happening, and he's only with them later doing something stupid with the money, which you do have evidence of, you can't find him to be a principal in the first degree. The state doesn't meet the elements of that charge. The state says that Trayvon is bragging about having stolen the victim's money. Do you hear anybody bragging? No, you hear music, and you see guys doing stupid stuff with money, flashing it. And the point I made with Detective Curcio, that, hey, in this social media age, if you go on the internet You look for people flashing money, you're gonna see hundreds of people flashing money. It's something big, it's done by young people these days. It doesn't mean anything. Not unless you can link it to Trayvon Newsom knowing he's participated in murder and robbery and he's flashing the money to be bragging about it as the argument is made. But the evidence doesn't support that. And as I pointed out to Percy, you admitted, yeah, tip box, 2 boxes, thousands of tips. Plenty of other people flashing money in those tips. Doesn't mean they're guilty of anything. Simply means they're doing something that for some reason is possible. Is popular in this day and age. No evidence whatsoever that once they're flashing money, and the state pointed out, there's a couple of minutes between those 2 videos you see of the flashing. No evidence that Trayvon didn't say, okay, now let me pose. Let me show you take the picture. As they suggested, somehow Trayvon took the first video without any evidence to support it. Simply supposition, okay. Even if it did, again, even if they did tell him they had robbed someone and killed someone, him posing with them in a stupid fashion, in a youthful, ridiculous fashion, doesn't mean he's a murderer or a robber. Only evidence.
Okay, he's just a knucklehead.
And evidence that you don't have says that
You knew it was coming.
more important, the evidence that you do have says he wasn't even there and is not involved. 2 gunmen, 2 masks, recovered from the search. Both have DNA on them, neither of which match Trayvon Newsom. This is the kind of evidence that supplants supposition and guesswork and testimony. It is acquittal evidence. You cannot convict Trayvon Newsom if the mask's DNA doesn't match him as the second gunman.
It is. It's the argument you got to make. It's not good, but what you got.
Do you remember at the beginning how the state tried to argue to you, well, but maybe they weren't trying to get the necklace? They even had Robert Allen testify, well, somebody said don't get the necklace because it has a clamp on it in the back and you'll have trouble getting it off. How long did that last? Every other witness talked about, yeah, they were definitely trying to grab this necklace. If you want to use common sense, that would be the easiest common sense to use. If you're going to rob someone that's wearing this around their neck, this is what you go for. Maybe there's money in the bag, maybe there's not. How would they have known? This, I have no idea what this is for. This is a small fortune. This is the target of those robbers. This is what was fought for on that video. This is what the individuals who didn't have gloves on tried to rip off his neck, which we know from the man who was in the car with him. Just say on board and said, I could tell they were black males only because they didn't have gloves on and I could see their hands as they reached in. He's right there. He's right on the scene. Even the blood on the necklace. Remember at first when they talked about it? Oh, if it was soaked in blood, it could, disperse the DNA. Was there any testimony it was soaked in blood? Witnesses after that, one by one, talked about how even at the hospital, they're trained. They're not going to wash this off before they take it and preserve it in evidence for law enforcement. And she says, you can still see the blood on there today. Yeah, if you look real close, it's a little bit of blood over here on the back, closest to his body, where it probably dripped down. The front is like sandpaper. It's abrasive. If you're going to get DNA from your fingers by touching something, you couldn't find a better object to leave DNA on because it's going to scrape right off. Even at one point, Detective Walcott, in questioning by Ms. Buckley, she tried to get him to say that if you touch something, you may not leave DNA. He said, well, I'd expect to find it there if you touch it. I think she was using this as smooth surface as an example, not that abrasive necklace. Absence of that DNA is crucial evidence for the defense. You would expect to find something from the real second gunman somewhere in all of this evidence to link him to this crime. No DNA in the car. No DNA in the necklace. Even the comments made by the state about an alleged text message from Trayvon about money buried in the backyard. Well, aside from the fact that they dug up the entire backyard and didn't find anything, which we cast doubt on the veracity of that, where's the text message? Because I introduced it evidence to you. If you look at it, they say a picture. Trayvon was attached to it. Where's the picture? You're the jury, ladies and gentlemen. You are the judges of the facts. It is incumbent upon the state to present evidence to support what people say, even police officers. You don't just take things at face value and say, well, it must be true because someone said it. You look for the evidence that proves it either existed or didn't exist. No photograph, no copy of the text message, no screenshot of the text message. The phone number that was made from doesn't come back to Trayvon. No way to trace it to him, if it happened at all. No testimony from the person who allegedly provided Detective Curcio is presented before you. Why? Well, remember, that testimony didn't even come in until the state's redirect examination of Detective Curcio. It was not part of their case in chief. So when they got up after I asked a few questions about these tip boxes, that's when, in the guise of talking about a tip, he started rattling off about a text message. Sure, that may have been the reason they did the search, but the search turned up nothing that would support the text message being in any way truthful. And I submit to you, ladies and gentlemen, the second gunman is still out there, with every reason to make you believe that they got the right guy. If you want to speculate on something, let's speculate on that. As being the person that would send that anonymous message, attach a picture of him to it, and try to get a jury to believe that he somehow admitted he participated in the crime. With a piece of evidence you don't even get to consider, this is not the kind of evidence that a reasonable jury can rely on to convict a man of first-degree murder and robbery. Ms. Shield had brought that up by likening it to a tip box in a case where thousands of tips are received, literally boxes. Detective Curcio himself testified that, well, yeah, I looked at all of them, but none of them had anything to do with my investigation, because they had already focused on Trayvon Newsom, because he went back and handed them his license and said, hey, I was driving the car in this accident. Why would he do that? Well, maybe he rented the car and had to get it back to the person that, no, he wasn't even there when it was rented. Did someone ask him to do that? Did he put up to that? Why would he do that if he knew that that car had been involved in a robbery murder just a few hours earlier? That's evidence that's here going on. It's not on the surface of the state's limitation or anywhere considered in it. It's something you have to think about. It makes no sense. It's evidence of he doesn't know at that point what they did, or that car is involved, or he would never have gone back. Two guys jumped out of the car and never come back, right? Why did they not come back? But he does. He's not the one who's with them. That's why he gets sent back to get the car. All right, let me start my presentation. Recall that the presumption of innocence and the state's burden of proof are two incredibly important features that jurors have to look at, seriously embrace, to make a correct decision in a criminal case. Trayvon sits there still presumed innocent at this point, because you haven't heard everything. You haven't gone back to deliberate and talked about the things that you've heard in evidence or the arguments of counsel. So in that light, and remembering that all evidence must be proved beyond the exclusion of every reasonable doubt for conviction to result, and that all 12 of them are needed to agree that the proof is so clear, we believe he's the one. And the promises you made to us that causes conviction to the jurors in this case to decide the fate of these three young men. Consider that as the backdrop when you begin your deliberations against what I'm about to go through. Crucial point in this case. Judge Usan already said it to you. He will say it to you again. And I'm quoting him. Although the three defendants are being tried together, there are three separate cases that are being considered at once, just for the economy of not having to call each witness over and over again. But you are to consider the evidence that's adduced at trial as it relates to each individually. And your verdict as to one defendant should not reflect your verdict as to another. Does everyone understand that? All of you replied, yes. Judge Usan again, can you all follow that? All of you, yes. I absolutely believe that you can. That if you do, and if you separate the evidence here and do not engage in guilt by association, because clearly he knows each other. Clearly he was friends with Robert Allen, stayed at his house for a while. You'll realize that the case against Trayvon Newsom is way fully short of proof beyond reasonable doubt. The state case against Trayvon raised questions about him possibly being involved, but provided insufficient answers, and in fact, the evidence the state presented raised numerous reasonable doubts on its own. Evidence in a criminal case and the reasonable doubt that can flow from it comes from lack of evidence, conflict in the evidence, or the actual evidence itself. This is a case, and it's unusual, where the evidence itself provides a strong probability, I would suggest, that Trayvon had nothing to do with it. The masks alone, the lack of the DNA anywhere, or fingerprints, or anything else that matches him to the crime, and the inexplicable cell phone evidence that places him miles from the scene just minutes after the crime happened. They can't have it both ways. They can't use cell phone evidence to convict two men and say, well, you shouldn't really consider it about the third man. It goes opposite. The evidence shows Trayvon could not have been there with him. The cell phone is alive and working. And by the way, remember how this all started about the cell phone for Robert Allen again. I talked about it in my opening statement. And then the next day when Robert Allen is testifying, the state asks him about Trayvon Sylvia. Do you remember what he said? Oh yeah, now I remember. His phone was dead that day. He wasn't using it. Aha, that's why it doesn't show him being near the scene of reload. Too early on. Later on, Detective Curcio tells you, hey, the cell phone evidence, which was properly gathered, it doesn't lie. It has no motivation to lie. It is what it is. Shows his phone was on, receiving and making calls at times that place him outside the involvement of whoever else committed this crime. Almost impossible for the state's theories to work together to convict all three of each other. Trayvon Newsom was not that other young man. He was not there. So let's talk about Robert Allen a little bit. Other counsel I know is going to go into great detail about Robert Allen's testimony. I watched your reactions to it, all heard all the different times he lied, all through all of the statements. I won't go through them each individually. I'm sure you'll have heard all of that by the time you're done hearing the closings of all three counts. But I'll just point out a few things about it that I think are most important for you to consider. The testimony of Robert Allen points out the clear legal distinction between physical evidence and testimonial evidence. Physical evidence cannot lie. It has no motivation. It doesn't change based on who's talking about it. It is what it is. People, however, are flawed. Their testimony can be changed. It can be influenced by what they want the jury to believe, or by their own perceptions or misperceptions of what they think they saw.
Okay.
There's no way.
Finally, the defense
physical evidence.
is dumping on
That's
each
why in
other.
this case,
Good
physical
times.
evidence will acquit Trayvon Newsom. Testimonial evidence, like Robert Allen, was damning against him in every which way you could imagine. I mean, he tried 5 different times to change his testimony to fit what the state wanted him to say, to fit their version that this is the missing gunman. He gave him anything he could possibly do. And he even confessed to the fact that if he could get these 3 men convicted, he's hoping to walk out of here in a matter of weeks, maybe a month or 2. 5 or 6 years he's hoping to serve. So his lawyer told him, hey, if you cooperate and give them what they want, you can get 5 or 6 years here. And won on this. How could you have a greater motivation to lie? But he's not good at it, thank God. Let's point out how he's bad at it. Well, let's start from who he is, okay? He's a 12-time convicted felon. 12-time convicted felon. And at one point, he kind of defended that by saying, hey, I do fraud. Remember that? I do fraud. That's why I'm 12-time convicted. What is fraud? It's a systematic pattern of lying to take advantage of other people and steal things from them. So he's basically telling you, listen, you really shouldn't believe me. I do fraud. But I'm going to say anything they want me to say to get these young men convicted because my life is on the line. He walked right through the cameras at Reba. He's right there. You can't mistake Robert Allen. I think a few people have kind of joked about that. He's a clearly recognizable individual. He was cold. He was dead in the water. Had something to say. Do you think for one moment he was going to tell guys, wait a minute, I'll give you what you want, but you got the wrong guy? Where would that have landed him? He's sitting over there, maybe without Trayvon Newsom, but sitting over there, looking at life. So what did he do to lie? He lied again and again and again. Nothing to lose. He's an admitted liar, a fraud guy. He is also a cooperating witness, which you've heard the instruction once, you've heard it from defense counsel, and you'll hear it again from the judge at the end. It is a law that has come about after many, many years of jurisprudence in this country, and in many, many cases where it's become absolutely clear and apparent that if someone flips, so to speak, becomes a cooperating witness, testify against the people he says he participated in the crime with, you gotta open your eyes to that. You gotta look at what the motivation behind that might be. And you gotta look at his testimony against the other evidence that supports it or contradicts it. And here, all the physical evidence points against what Robin Allen said about Trayvon Newsom. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or hopes to gain a more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. This instruction could have been written for this case, but it's been around for many years, and it's something you have to take to heart and have to use when you evaluate Robert Allen. 5 statements he made, all under oath before the trial, all different, all packed with lies. Even his trial testimony was contradicted in some ways by other witnesses and by the evidence itself. Ladies and gentlemen, you cannot trust his testimony. The judge will tell you again,
I might actually do a fun one tonight,
You
later.
to believe or disbelieve all or any part of witness's testimony. You need to disregard everything Robert Allen said. Everything he said. It's unreliable, it's incredible, and it's not worthy of consideration by anyone. I know co-counsel will talk more about it now. But as it applies to Trayvon Newsom, it's the clearest that he's lying to get himself the deal that he's wanted all along, all those years it took him to finally get it. There's nothing he wouldn't have done, nothing he wouldn't have said, no testimony he wouldn't have twisted to get himself out of this. At the very start of his attempt to get a deal, Detective Curcio and Detective Bronson, in speaking to him, made it clear to him that he had to testify to what their theory of the case was in order to get that deal. That's in writing. That was in the transcripts. There's no way they can get around that. That is a violation of all the principles of good detective work that start with don't put words in the witness's mouth. Let him tell you what he says happened. Because you're stuck with it. Because if you twist it, he's either a liar or you're the one that's putting evidence in there as a detective. So listen to how it goes. Halfway through his October 23rd, 2018 statement, not long after this happened, Detective Curcio says to him, we've got to go over some things here. The issues you know, obviously, again, when you work this out, a reference to getting the deal he's trying to get by being there and talking to them, you're going to have to convince a jury that everything you're saying is 100%. And even the little details, like when he's asking you what was being said between me and the other guys, you've got to kind of remember everything they were saying. This is after Robert Allen had just said, I don't remember. What did he say? What is he telling him to do? I don't remember. Well, you got to remember. He's telling him to tell us what you want to hear you say. That's clear. Even Robert Allen understood that. He wasn't going to be able to tell them what really happened and get his deal. He had to tell them what they needed to hear to get all three men in this crime. Because the police had already focused by October 23rd, 18 on who they wanted to take to trial. But a couple pages later, in the same record, Robert Allen admits it. He says, it's like you're trying to push me to say something I don't know. They danced around it a little bit with him. That's what the transcripts reflect. That's what the record is. That was the end of any chance of getting him to actually tell the truth. If there was a chance, and it probably wasn't, but at that point, it's over. He's going to give them what they want to hear. But he still wasn't very good at it. It took him 4 more sworn statements, 4 years to finally get a prosecutor to think she needed to use his testimony. And if she did, she had nothing against Trayvon Newsom without it. Nothing. In fact, everything points the other way without it. But you can't believe Robert Allen. You can't convict Trayvon Newsom. Detective Bronson finishes it up. Coup de grace, right at the end of the statement. To Robert Allen from Detective Bronson, who, by the way, was working for the state attorney's office at the time. So investigating them. This comes to fruition. Well, that means if you get your deal, Mr. Allen, you need to think about this. Because if all of a sudden you remember something during the trial, they're going to shove it up ours and your rear end. Give us everything you want now. Stick to your story. Don't waver. No matter what those attorneys try to say on cross-examination. You stick to it. Don't change it. Don't add anything. Of course, he did anyway. He added a couple things that didn't make any sense. That the cell phone data refuted, that the DNA eventually refuted, they finally did the testing.
So far, I'm
Say,
getting
by the way, Trayvon wasn't with me that day, guys.
my client's guilty, but boy, I'm innocent. But these other guys are sure guilty.
Remember when Robert Allen testified about the alleged outburst by Trayvon Adam? I didn't really challenge what he said across his animal. Because it was clear my client was cool. Told him what he thought of him. Called him a bitch. Cursed him out. Still, they put Deputy Alvarez on again because how could you believe Robert Allen alone? Then, snitch becomes bitch. What a distinction. But who are you going to believe? Deputy Alvarez or Robert Allen? And of course, the state focuses on snitch. They like that word. That fits the case. For what he said was bitch. And he went on to curse him out. Somehow evidence of guilt is being introduced as evidence of guilt. An outburst by someone like that. That's evidence of guilt. It's evidence of being a person and being angry. That's what it's evidence of, clearly. Nothing else. He lost his cool. Had a former friend who agreed to tell the story that deputies wanted to hear. After they saw Trayvon on Robert Allen and the other social media, and he placed himself in the Dodge Journey a couple hours after the crime. They were going to back off on their theory. that was their best chance to get the third guy here, the guy with the gun, after they'd already locked in. There's nothing else they could do. Okay, so hopefully you understand that Robert Allen's testimony should not be believed or relied on. So what does the credible evidence actually prove in this case? Well, credible evidence doesn't even come close to proving or beyond reasonable doubt that Trayvon can be convicted of armed robbery and murder. No firearm recovered that can be matched or linked to Trayvon. No witnesses, other than Robert Allen, put him at the scene of the crime that day. Robert Allen said the guns found at his house were not one of the guns Trayvon had that day. Why? If all the guns are together, why wasn't Trayvon's there? Well, Trayvon didn't have the gun, he wasn't there that day. They wouldn't find his DNA on any of the guns they found, or his fingerprints, or anything else they used. So Robert Allen's a liar, but he's not an idiot. No evidence of proceeds from the crime are recovered from Trayvon, even from the alleged search in the backyard where there's supposed to be all this money buried. Believe me, they did a thorough search in that backyard, dug it up. Nothing there. That's the house that Trayvon lived in since he was a kid. He was 18 years old. No DNA anywhere on anything matches Trayvon Newsom. No fingerprints except on the Dodge Journey, which he drove, clearly. And again, you saw the video. It's kind of funny how things help you to come to the right conclusion in a case that you wouldn't expect. You see one man having trouble backing it up. So Trayvon takes over and backs it up just fine. So you see how Trayvon ends up the driver of the car. No cell phone evidence places him there. In fact, it's to the contrary. No credible witnesses. No proof Trayvon's even at Reba that day. No less that he's the shadowy person you see in the video jump out of the car and to brandish a weapon. Again, he goes to the scene of the crash afterwards. He runs because the other guys jump out and run. They don't come back. He does. Because he was driving the car. He has purple license. Not Trayvon's. The car was just using that driver. And even, didn't Robert Allen say that they had just learned before this crash that the victim had died? Didn't he say that? You should correct your recollection. Okay, so even if, how would that be true? If Trayvon, even if he knew at that point that they had robbed and murdered someone, and hears from them that the man died, he's going to go back and identify himself with his license in that car. Not the brightest thing to do, your mind. No evidence of guilt. Even though law enforcement's there on the scene already. And he goes back. Again, look at the photo lineups. Everyone's clearly in there. The rental of the car. He had nothing to do with rental of the car, so no reason for him to go back. Crime scene detective Walcott testified about a lot of DNA evidence. But he also gave us some other important testimony that's consistent through all the law enforcement officers in this case. DNA is crucial in criminal investigations in 2023. It is sophisticated, the testing is incredibly sensitive. They can now test mixtures of many people's DNA and tell you who was there and who wasn't. It can be incredibly important in identifying the correct suspect. And it can also be incredibly important in showing that someone is not the correct suspect. In this case, the police ignored that because they were locked in under theory already. This case was closed by the time they got their DNA results back. So they just went. Every cell of the body contains DNA, blood, saliva, skin cells. But the necklace, no DNA on that abrasive surface of the necklace. No DNA in the car, in the BMW, anywhere that you can see the violent struggle in there. Allegedly, the second gunman reached in from both sides of the car. No testing, even done of his clothing. Even though clearly that would have been touched, trying to get to the necklace. Ladies and gentlemen, again, remember, the defense has no burden to go out and do these tests ourselves. If the state wants to convict someone of murder and you got no DNA evidence, please test everything. Please test everything. They didn't. On them, not on us. Remember, even Wolcott testified that while he's at the hospital, law enforcement already knows the necklace is a very important piece of evidence in the case. His words, not mine. Because it was obvious from the video and the live witnesses all agreed there was a violent struggle for the necklace. At the beginning, the state tried to recede from that violent struggle for the necklace by putting on that ridiculous testimony of Robert Allen. That, oh, somebody said that it had that kind of clamp on it, so don't go for the necklace, just get the bag. Ridiculous. Remember, too, witnesses were able to say the suspects were black males only because they weren't wearing gloves. No DNA of Trayvon's, any of the swabs of the BMW, and remember, they swabbed it all over the place. Detective Walcott also testified on cross that no one at the hospital would wash a piece of evidence like that necklace in any way. They know this is a murder investigation, or it happens to be, maybe it wasn't pronounced yet, but certainly a robbery with a shooting. And he's there, he would never let them do anything to it, it didn't preserve the integrity of it, so it could be tested. The blood on it had nothing to do with the fact that it was DNA on. You can see it, look at it, there's the tiniest little bit of blood, that was not bathed in blood or soaked in blood, as the state started to suggest, maybe we didn't get DNA because it was so drenched in blood, maybe they washed it off. This is all just some big mistake. No. It's a lack of evidence. Reasonable doubts come from the evidence, conflict in the evidence, and lack of evidence. The state tried to argue, supposing, well, there's no proof that if you touch it, you would have found it. That's called burden shifting. That's called the state asking you to look for the defense.
That intelligent popcorn.
Oral argument during the finance on recollection.
Thank you. Remember the burden. The state accepted it.
I didn't hear that objection.
It's all on us. We gotta prove it. They don't have to do anything. We do as much as we can, but the burden doesn't change. If we try to present evidence to you, the burden is still on the state. In this case, I have no additional evidence to present to you. It's all there. It's the masks, it's the necklace, it's every other piece of evidence that was tested in every which way that shows nothing linked to Trayvon Newsom, except some stupid photographs. So detective, just because I touch something, does that mean I will leave fingerprints? Detective Walcott, no. Ms. Buckley, just because I'm touching all these items, Detective Walcott, no. Ms. Buckley, just because I touch it, am I going to leave DNA that you would be able to test later on? Surprised by the answer? Yes. You probably left some DNA right there when you touched it like that.
Oh, good
I almost
Lord.
fell off my chair. That's integrity. No,
Go kill killer.
Call it like it is. I'm not going to give you what you want out of the prosecutor. Just because you want me to say we got it. You expected to find it on that necklace. That's an important piece of evidence. We expected to find DNA on it. We didn't. That's lack of evidence. No DNA or fingerprints of Trayvon on the bullets, the Jordan bag, the BMW, the necklace, the fingernail clippings. Anywhere we would expect to find it if the state was able to prove he was the second gunman. In fact, he was there. Cell phone. Detective Curcio agrees that DNA and cell phone evidence are extremely important in police investigations today. In my opening, I talked about the fact no cell phone evidence links Trayvon to this crime. Then, of course, we get the testimony from Robert Allen. His phone was dead. Well, they had his phone number. Police told you that. They obtained a warrant to get all the data they could possibly get from him. They did. There's nothing in that data supported him being in Riva. In fact, basically proved he wasn't there. He could not have gotten to a different city that many miles away. But that call bounced off the tower that far from Riva in 5 minutes, 3 minutes, 3:57 to 4:02. Couldn't happen. Getting Robert Allen to say that was obviously an attempt to get him to make a more favorable impression on the prosecutor. We hoped that he would say something that would help with that problem that they have with the phone evidence. And again, he was open about this. That's the prosecutor's going to make a recommendation as to how much time he actually serves. And he was honest. He knows he can be convicted. He's got a much better shot of walking out. 1:55 p.m. Trayvon's cell phone's in Pompano Beach. 4:02 p.m. 5 minutes after the crime. Still in Pompano Beach. Now, the state made a big deal about the fact that he's in that video in front of those apartments switching the driver of the car. It's an hour and a half after the crime. Obviously, plenty of time for him to rejoin his buddies back down in Fort Lauderdale. For them to either tell him, hey, look what we did, or not. Just put him in there, not know. Go back in the car. They won't the license. Never would have done it if they didn't involve in that crime. There's no reason for us to do it. Everybody ran. They ran from the car. He ran because they ran. Why am I running? I'll go back. Entirely different city than Deerfield Beach when the crime happened. That's what the way Detective Curcio had to admit. The second call placed to his phone, one's phone, proved through the phone evidence. Again, the state wants you to draw logical inferences. Use your common sense. I think you should use evidence or the lack of it. But if you want to draw inferences, that infers pretty darn clearly is he was never agreed that day. Yeah, he was with Mr. Boatwright down by Robert Allen's in that car later on. You all agreed in your diary that guilt by association would not be something you consider. It's not the law. You won't hear any law that tells you that because somebody has, poor choice in friends or associates, that they can be convicted of a crime that those friends or associates may or may not have committed. Guilt by association has not something the law forbids. You need evidence, and it has to be evidence that proves the elements of the crime beyond a reasonable doubt. In my opening, I asked you to consider whether or not in your life experiences, using your common sense, at the end of the testimony of Robert Allen, you would find that he's someone you'd ever believe anything out of his mouth if you knew the things you knew that you heard in this trial. Obviously, you would not. You would buy a car from him. You would believe anything he told you once you knew. And he would say whatever it took for him to get his chance of freedom. That's his motivation to lie. Discuss it among yourselves when you deliberate. And you, the jury, will see what the facts prove and they don't. And you'll have to concede. Robert Allen, you just have to disregard everything he said. The state case raised some questions that it did, but they provided insufficient answers to those questions. In fact, the case itself raised numerous reasonable doubts. Again, a reasonable doubt is from the evidence, conflict in the evidence, and lack of evidence. You have all three of those here. Very present. Very long case. Ladies and gentlemen, I thank you so much for your attention on behalf of my client, Trayvon Newsom, and his family. I pray that you make the right decision in this case.
Councilman Williams, would you close? Take 5.
Thank you so much.
These gentlemen, please come back.
All right, that was Larry. Now we're going to go to Curly.
I started off in my opening talking about the foam fingers that they had at baseball games and regarding prosecutors. And a lot of times I use that metaphor that many of them, they put it on and they'll come in here and they'll be like, this man and this man. And I really, to the point that I've been doing this 20 years, and I really think that in prosecutor school, day one is just pointing, the whole day, just practicing pointing. But in this country, you convict somebody not on the power of a point, you convict them on evidence. And as talented as Mrs. Shields is, she's been put in a rough position because she has been given a cast of characters for witnesses that's akin to like the bad news bearers of witnesses. I mean, the list, I'm gonna go through it right now, but she was put in a very bad position when she had to take this case because the witnesses that she has don't have credibility. And you, as jurors, it's
Usually, but I don't know what it is.
not only listen to someone that's testifying, but to judge the veracity and figure out whether or not they're saying the truth, whether it's a layperson, whether it's an expert, whether it's a law enforcement officer. As jurors, it's your obligation to listen to them and to say, are they saying the truth? And I've seen you guys paying attention, and I want to walk you through the witnesses that we've heard from and figure out exactly, where the issues are with their case. Let's start off with Scott Barbour, the guy that was on the scene. What do we know about that guy? Well, I mean, between me and Dietrich, we call him Interview with a Vampire because he came in here and Mr. Shields had to tell him, hey, take your sunglasses off. He walked up there, he testified. What do we know about him? Well, we know that he asked Mr. Onford for a picture, and when he didn't get it, the first thing he did while the guy was laying there dying is he went and he took that picture. That he told him no, he finally took that picture and he posted it. And you all heard from the medical professionals and other witnesses that Mr. Onford died in the hospital. So this state witness that they put up there is an individual that watched somebody that was in distress and took a picture and posted it. So if that doesn't tell you a little bit about his credibility, I don't know what does. I looked at him and I was judging. I asked him if he was sober. He said he was. He didn't look at me. But you guys can make your own judgment calls. You could use your common sense to see whether or not that guy was credible. I don't think he was. Now, what did he do? He contradicted his girlfriend, his ex-girlfriend, Miss Layla Khan. Miss Layla Khan got on the stand, and really, the main thing that she said was that they were running towards Rigo when they heard the shots, which is in contradiction to what he testified to. And I asked her, and she did contradict him. That's one of the many state witnesses contradicting other state witnesses that you've heard in this case. But really, from Layla Khan, I think one of the most important things that we heard from her is that she broke up with him. And I heard a collective sigh of relief. We're like, oh, thank God, poor girl. Then we heard from Leonard Kerr, the best dressed Uber Lyft driver that I have ever seen in my life. That guy was Gucci down to the socks. But he wants us to believe that he lives in a multi-million-dollar house apartment mansion. He said, I don't know how much it costs. Now I don't live in a mansion. That he makes all his money from Uber and Lyft, that he's not involved in a Jamaican crime syndicate. However, he had 2 humongous bodyguards sitting here for 2 entire days. And when I pressed him on it, what did he say? No, my family pays for it. Okay, but who in your family? No, my family pays for it. Okay, my niece got a car for her 18th birthday. My family helped her. My sister paid for it. You know what I mean? Like, so I asked them, who's paying for that individual? Because I would like to know, and I believe that the jury should know, whether they're there to guard you or they're there to ensure that you're testifying the way that somebody wants you to testify. And I think that that's a valid question. I couldn't even get there because you refused to answer who was paying those guards. And as jurors, you guys should be able to know that because it goes to the veracity of that particular individual. It was a simple question, and he refused to answer it. Then there's the issue of, while the whole thing is going on, I think that the state referred to him as the step-uncle. While the whole thing is going on, he takes out his phone, he calls Cleopatra Bernard, the mom, and he never even walks up to the car. You guys can make your own determination because honestly, I'm not going to say it because I've never been put in that particular position. I just think it's really strange that it took him that many minutes to approach the vehicle. Okay, and then he's out there calling Cleopatra Bernard and not really involved. He testified that it took minutes and minutes. The police got there, so it was a long time, and that's strange. I'm not gonna fill in the blanks because I'm not gonna tell you something that I don't know, but you guys can think about that. Why is that weird? Why did he do that? Then the bank teller, Cecilia Ramos. Listen, I'm not telling you that the bank teller's involved in this. I'm telling you that a proper investigation could have included, hey, what's your phone number? Would you give it to us? I don't think that's out of the realm of the possibilities of a correct investigation. Why? Well, he went to the bank, he wanted $250 million, he took 50, and then all of a sudden he went and got robbed. Whether or not Cecilia Ramos was involved or not, we're not going to know because they didn't ask her for her phone number. Yep. And they couldn't. We're getting there. 15 minutes. It highlights tunnel vision, and which is really one of the main things that I said in my opening, and it really affected the investigation of this case. And tunnel vision is like termites to the foundation of a house. If you are an investigator, you have to look at all your options. Okay? And bottom line is no one ever asked her anything. She said that he was in a good mood. Mrs. Shields brought that up, that he was in a good mood. Well, that contradicts Scott, because Scott said that he wasn't in a good mood when he refused to take that picture that he eventually took. So that's another state witness contradicting another state witness. We have Tony Robinson. What's the most important thing that you heard from Tony Robinson? That she rented the car for Robert Allen. That Diedrich told her, hey, Robert Allen needs a car. Not we need a car, Robert Allen needs a car. And then she refutes the allegation that Allen made that they were renting cars every day. He said that, we're renting cars every day. I asked her, she said no. Tanisha Clark, the lady that will never rent again on Turo, the worst first experience of any Turo rental ever. The most important thing that came from her was that my client had nothing to do with that rental. Robert Allen was the one that rented that car. Mrs. Delgado, the lady that works for Just for Sports, what did you hear from her? You heard that Diedrich was a frequent customer, that he always paid cash, that many people at that location pay cash, that it's not, a rare thing for people to pay cash there. And every time that he would come in, he would buy more than he came for. Okay? From all the state witnesses, you've heard that Diedrich was the kind of guy that had money. From tattooing, from different things, he had money and he would pay in cash, and she bolstered that. She let you know, he would call and he would pay for cash. They want to make it seem that, first of all, that $800 is a shopping spree. I think anybody here that goes shopping knows that it's not. Okay, $800 can go quickly. They're making it seem like, and he bought different sizes. I mean, he went and purchased $800 worth of clothing and shoes at a store. That is not an admission of guilt by any stretch of the imagination. Tennelle Carter, Diedrich's ex. Her testimony was, if you listen to her testimony, because they took some time to get what Diedrich told her, right? She just said that he was there, which, when Detective Kershaw was on the stand, and they tried to elicit the same testimony, that's what I said there. There was a lot of people that were there. Scott, Leila, Leonard Kerr, everybody at Riva. There is there. There's a very broad term. And I think they had the obligation to narrowly tailor that in their testimony to figure out, was he in the car? Where was he? But they didn't get that out of Tennelle Carter, and they didn't get it out of Detective Kershaw. Actually, if you want to put him in the car, which is one of the things that I told you in the opening, if you want to put him in the car, if you want to say that Diedrich was part of this crime, you have to believe Robert Allen. Now, there's video. There's video, and I'm not going to waste time showing you the video because I know that in a case like this, that you guys are probably going to go back and read the evidence. and the video is probably one of the things that you're doing. Okay, and I'm asking you to do it, okay? And when you look at it, look at the video, and you're gonna tell that you can't tell if somebody got out of that car. They're acting like if it's clear. It's not clear. It's obstructed by a tree. Eventually, a car rolls up, pulls up. They open up the trunk. Things happen, and you can't look at that and say that because of that video that you can tell beyond a reasonable doubt that Diedrich didn't get out of that car.
Things happen.
It's there, which I'm glad it's there because as jurors, you don't need a detective to tell you what a video shows. You don't need anyone. You guys have two eyes, and you can look at it for yourselves. And I'm asking you to please do that. Tanel also said, yeah, he would make up to $1,000 a day. That's what people. I think I'm in the wrong line of work. He also said that it wasn't rare he didn't use a bank account, so it wasn't rare for him to have maybe up to $50,000 in the house. He would squirrel it away and have it. She also said that he was constantly playing with money. You know this, and Detective Kershaw, when I asked him, also agreed that it's not the first time that he's constantly boasting with money. And yeah, listen, it's an indictment and it's kind of on his personality, right? But it's not an admission of guilt. It isn't. It's kind of dumb, and I don't think that he should be doing it. It shows that it's kind of silly that you're doing it, but it's not an admission of guilt. Then we have Detective Clint Williams, or I'm sorry, lead crime scene investigator Clint Williams. This is the guy that's obsessed with buttoning his blazer. That every time he got up, he was buttoning the blazer. He's obsessed with that, right? What did he say? What did you hear him saying? And this wasn't a cross-examination. He said it himself. I consider that a win. Really? Because no one was talking about winning or losing. That came out of his own mouth. I don't really believe that guy. And the one thing that I believe is that he doesn't get invited to the parties. But I'm gonna tell you right now, they have parties, and you're allowed to have a party. What if you believe in your case and you spend 9 weeks trying to convict somebody that you think is guilty? You think if you win, you're not gonna go have a party? And it's okay. It's normal. You know what's not okay? To come in here under oath and then lie to a jury about it. Why? It's a simple question. I asked a lot of questions just to see what the response was, and that's one of them. Because the correct, honest answer is yeah. Yeah, what's wrong with that? But he didn't say that. He didn't say that. You have to use your own common sense, and when you look at somebody like that, you have to see, listen, is he a criminal person? Forget about whether he's a crime scene investigator or not. He's the guy that found the live cartridge, Exhibit 29, right? Okay. I wish we had maybe a video of him finding it, but apparently, even though BSO, everybody has cameras, including the ladies and gentlemen that are here today working for BSO on their person, coincidentally, a lead crime scene investigator working a homicide on a search warrant doesn't have it. Sorry, we stopped using that a couple years ago. Why? Why? Because it would have helped you guys, right? It would have helped you guys and would have solidified whether or not I'm saying that you put that there. Well, if you had a video, we would have to think about it, but we don't because they voluntarily a couple of years ago decided to stop using it. But every other BSO running around in this courthouse, on the streets, patrolling the streets has one. But crime scene guys, they don't have it. I asked them, speaking of questions, to elicit a response, I asked them, have you ever missed out on an important piece of evidence? And if you guys remember, his response was like 4 minutes. Blah, 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 and then finally he went, blink, the light bulb, blink, the answer. Oh, I don't know. Yeah, that's the answer. That's exactly what you should have said right away. I don't know. I don't know if I missed it. I don't know it. But he took the long way home because it's a thin line between law enforcement officer or professional witness. Because a professional witness comes up there and they tell you whatever Mr. Shields wants them to say to get a conviction. And what he started off with the explanation when the answer was clearly, I don't know. Now, another question that I ask frequently, okay? Isn't it true that you can't tell whether that's real money? Detective Cursor, oh, you want my opinion? A bunch of people, they didn't want to answer that question. The answer's, no, I can't. Simple. It's a video. And whether she wants to say, oh, they're crisp, they just came from the bank, it's a video. It's a physical impossibility for you to look at a $100 bill on a video and tell me if it's real or not. And I'm not saying that the money involved in this case is not real. I'm just telling you that the correct answer, the honest answer is, no, I can't. I'm a human being. I'm not a robot. I don't have X-ray vision. I can't tell. I need to touch it, test it. The answer was clear, but every time that I asked it, they gave different answers. The forensic guy, Marshall Walcox, I think that I don't want to mispronounce his name. He was a pretty believable guy. From a law perspective, I believe him. What's the most important thing that came out of him is that DNA can stay on something for years. And I use the example of I like to go snowboarding. And if my friends ask me for my stuff, which they often do, and I lend them a mask, and they wear it 2 seasons later, is it still going to have their DNA? And he said, yeah, it's possible, right? And another thing is this: it's a mask, and the DNA the DNA expert that was on the stand, I think we talked about that it's an item of of high absorption. I mean, you don't have to be an expert to figure that out. It's a face mask. You're breathing on it. So, regarding the face mask that was found with my client's DNA, that doesn't mean anything. That means that he wore it. That doesn't have any association of guilt. That means that at some point in the life of that mask, he wore it. And no one has given you testimony to narrowly tailor that. That's all that means. Now, it had 2 DNA profiles, right? We heard from Nicole, the DNA expert. Now, what do we hear from her? Well, there's something called star mix, that if they would have done it, it would have helped really figure out who that second person was. And they didn't do it.
Judge is struggling here. He is struggling.
So, Mrs. Shields wants you to believe that there's no reason for Dietrich to have a mask other than to rob you. Okay?
Yes, it is put up.
We entered into evidence from Tanel, a picture of him with all the entire outfit. You heard from the gentleman that worked at Riva Sports that he often bought equipment. So you have to ask, so what did she do? What did she do? She went to her go-to, Robert Allen. And then Robert Allen was like, oh yeah, no, he doesn't wear any safety equipment. Oh yeah, he doesn't wear any safety equipment. And that's when I was cross-examining him, that I called him fat. And you know what? If anybody should be calling anybody fat, it's me. But it came out. And the moral story is that his obesity is of evidentiary value. Why? Because if you're saying that my client doesn't wear a mask while riding a dirt bike, you're too big to ride dirt bike. The only reason that guy would ever get on a dirt bike is to take a picture and make a meme. There's no way a guy that size is ever going to ride a dirt bike. And so, unfortunately, his size is evidentiary value in this case. Another thing is that Robert Allen, I will get to this, Robert Allen was simply too large to be involved in this crime. You know what I mean? They would have been like, yeah, you know, it was the big guy that was here half an hour ago. It would have been clear. But it's clear from the evidence that you heard that he does ride dirt bike, that he does wear masks when he rides dirt bike, that he does use equipment. And why is that important? Because it contradicts what one of the state's witnesses says, Robert Allen, and it goes to his veracity. Now, regarding Robert Allen, Mr. Shields was quick to slip on the finger and be like, regarding my client, he lied repeatedly because he gave multiple versions to Detective Curcio. He lied repeatedly. That's conscious of guilt. Yeah, but what about Robert Allen? That sat here and admitted to perjuring himself. I don't know how many times. How many times? You guys sat there and you took notes. How many times did Robert Allen? Oh yeah, I lied. Oh yeah, I lied. Oh yeah, I lied. The only person that believes Robert Allen is Detective Curcio. When I asked him, "What? You know, he's straight up guy, straight shooter." He literally perjured himself and admitted to perjuring himself. As a matter of fact, he was such a bad witness that from her direct, Mr. Shields direct, to Mr. Kimmock's cross, he changed the version of the person that picked him up after that accident. It went from "I don't know" to "You don't want me to answer that question." Really? Because you were just on direct examination. All of a sudden, "I don't know" turned into "You don't want me to answer that question." And then when I went and I asked him, "Oh, everything blew up," but I'm scrutinizing your inconsistent response. All of a sudden, "You don't want me to answer that question." So then that begs the question, who picked you up? Because he got into an accident and within 60 seconds, somebody was there. So either, if he knows who that person is part of this. And he testified that he was scared of that person. Where's that person? That's another problem. They're not investigating this case.
Objection, silence.
In my opinion, she could basically get Robert Allen to say anything. I think that was clear. She says he comes with a host of baggage. Really? With a host of baggage, but you guys have to depend on his testimony to convict 3 people. He comes with a host of baggage. Brush it off. It's a host of baggage. No, he's a liar. He's an admitted liar, and they're asking people to take the word of an admitted liar to convict someone. Robert Allen stood up here and he was like, "Oh, I feel really bad. I'm remorseful." But he also testified that in the 5 years that he's been awaiting trial, what has he been doing? Getting face tattoos in jail. You're allowed to, as jurors, take that into consideration. He's coming up here and saying, "Oh, I feel really bad," but meanwhile, in the 5 years, thug life, just tattooing his face in jail. You can take that into consideration when testing somebody's veracity as jurors.
He didn't drop an irregardless, did he?
They also, Mr. Shields tried to blame the number of years between his arrest and his cooperation with COVID. And I think it was clear on the testimony of some of the detectives that there's no evidence for that. As a matter of fact, his attorney was involved in depositions, maybe like 6 months ago. When it was approaching trial, he said, "I have to make a decision." And that was the decision that he made. To save himself, he was going to involve and create lies towards his friends. That's what he was going to do. Now,
Yeah,
one of the
it's
main
gonna be
things that
awkward
they've
over
always
at the defense table
the entire time.
after they all pointed fingers at each other.
He never got a deal. He's doing this, but he doesn't have a deal. He's remorseful. Yeah, but he's never had a deal because if you guys as jurors would think that he had a deal, it would bolster the notion that he's just doing this to get a deal. So I know you guys heard that quite often, okay, about Mr. Shields asking him, did I ever give you a deal? Is there any deal? Is there any deal? I know you're relying on your own recollection, and this is not an official transcript, so we'll follow along with me here. This is Mr. Shields asking the question, right here. What kind of weapon did you say in October of 2018 that Trayvon Newsom had? This is before you had a deal. What kind of weapon?
Judge, I'm gonna object, this is not from the trial transcript.
Jury will rely on its own recollection of testimony presented at trial.
Answer, a handgun revolver. Question, do you recall telling Detective Kershaw in that same statement, before you had a deal, what kind of weapon Michael Boatwright had? So, there you go. I mean, very rare that one of the witnesses in favor of the defense's position is gonna be the ASA herself, but whoops, she said it. What is she gonna say now? She's gonna have to stand up here and say, no, I didn't mean that. Or, I don't know what she's gonna say, but she said it. That's the deal. Which, listen, you guys have common sense. You know that there's a reason why he's doing that. That just enforces what you guys already know. You cannot believe Robert Allen. Robert Allen, that coincidentally, I have 4 phones. 2 phones, like the song? No, I got 4. Why? Why do I have 4? Oh no, I do fraud. Simple. I do fraud. Oh no, that day I only had 1 because I took the day off from fraud that day. I took the day out. That day I was gonna go commit armed robbery, so I only took 1 phone. That's not. They're asking you to believe that. They're asking you to convict somebody based on that guy's testimony. And I know it's funny, but it really is not funny because at the end of the day, look at where we're at. And look at what they're asking you to do. That's a lot of pressure to put on a juror. Believe that guy, that liar. And the 1 phone disappeared, never to be found. We don't even know where it is. When I asked them what his dad did, they objected, and eventually he blurted it on himself. Oh, my dad, the drug dealer, one of the addicts, one of his dad's addicts drove him, he's bragging about his dad having addicts that drive him around. That's who he is. And apparently his dad was the plug or the guy that hooked everybody up, but he testified that at least some of the weapons in this crime came from his dad. So who's his dad? Well, we don't know because he passed away 30 days after he cooperated. We don't know the reasons why, but we know that he testified. If my dad, that he had intricate knowledge of his dad's criminal enterprise, because he told you, if my dad would have been involved with other people, whether it be Toronto or whatnot, I would have known about it. Okay? His dad arranged for him to flee this county. And his dad has never been investigated in this crime. All we heard is that Kershaw knows him. They go way back because, he's a detective and the guy was a criminal, so, they go way back. Now, Robert Allen, if you heard his testimony, Robert Allen says that Diedrich is the one that was telling him what to do, that Diedrich, egged everybody on, that Diedrich looked for the car on the thing, even though they never showed one bit of evidence of that regarding if somebody Googled the car or not, they didn't show you anything regarding that, even though they had his phone and they had it pretty early on. They showed you a bunch of stuff on his phone, but they didn't show you that. Now, you gotta ask yourself, who looks like the boss there? I mean, every time you see Robert Allen, he's getting driven around. Okay, he's in the back, he's getting driven around, but he wants you to believe that Diedrich is telling him what to do. If you see him on the video, look at the video. On the video, he's in there talking on the phone, walking around. What happened on June 18th? I think it's pretty clear that Robert Allen made a phone call from one of his phones or somebody else's phones and basically concocted what occurred. And Diedrich, what do we know about Diedrich? That's undisputed. He was a frequent customer to Revo. Everybody said it. Okay? So if anybody was going to tell him, are you crazy? I'm not going to do that. I come here all the time. But Robert Allen didn't care. And then the 8 minutes and 36 seconds or whatever it is that we had to sit vigil while ASA and Shields had us here in silence waiting, I'm glad you did that. That's the time that it took for Robert Allen to get reinforcements there. And you know what? What do we know? That he gets picked up like that after the accident in 60 seconds. So in that neighborhood and in that area, they got people all around. Who? We don't know.
He had
They
8
didn't
minutes
investigate.
out of
I
the
asked,
deal.
I asked the
Come on.
detectives regarding the investigation regarding that vehicle. I believe it was insufficient. I don't think that they ever followed up, because at the end of the day, it conflicted with their narrative. And to this day, anything that conflicts with their narrative, they don't want to hear about it. Which is a problem, because investigation shouldn't be like that. This is a murder investigation. You gotta think about everything. You gotta follow up on everything, not just get tunnel vision.
Plus, Drake did it. Oops. Oh, I wasn't
So when
supposed
you
to
look
say
at that video, look at it, and you're gonna see that it doesn't show what they're telling you. And listen, regarding Dietrich, what you've heard from Tenel and what you've heard from Detective Curcio is insufficient. It really is too thick. All the other evidence that is involved in him playing money and all that other stuff is still insufficient. They put you in the impossible position that in order to convict Dietrich, you gotta believe Robert. There's no way around it. And when you guys are in there, in that room, think about that and talk amongst each other. But there's no way around it. They put you in that position. You got to believe a known liar, someone that's already lied and admitted to lying on multiple occasions. Now, there's just problems with the investigation and things like that, like regarding Drake and Migos. You know what? We didn't drag Drake and Migos into this. We didn't. Okay, and that's clear because on her redirect of Curcio, she asked them, were you able to verify whether or not Drake was even in South Florida in June 18th of 2018? Yeah, we verified it. And then when I crossed examined him about it, oh yeah, no, my partner, Detective Foster, yeah, he checked. But he checked in 2018? Yeah, back when it happened. Okay, he checked in 2018. And how do you do that? Oh, he checked social media. Really? This is a murder case. This is a murder case where they've already, both Foster and him have said, no, they don't have anything to do with it. They have nothing to do with it. So if they don't have anything to do with it, why are you checking the location of someone at the time of murder? You're either a person of interest or a suspect. And that happened 5 years before I put him on my witness list. That has nothing to do with me. Part of this case from its inception. And it really baffles me, and it's really scary that BSO, once they take the step of saying, okay, we want to know where you were, anybody, in a murder investigation, okay, that means they want to know where you are. I think at that point, once the inquiry is official, I want to know where you were. It is insufficient to just say that your partner peeked Instagram or checked his Facebook. Oh, he didn't check in, he wasn't here. What is that? This is a murder investigation. You know what I mean? Like, if you care where he is, or you don't care where he is. If you care where he is, checking social media is insufficient. And apparently, that's all they ever did. That's all they ever did. Question, I understand that, but let me ask you this. At what point in this investigation did Drake's name come about in your investigation? Do you recall that? I believe it came from the anonymous information that was coming in earlier on after the murder. Okay, that's the first time I was aware, but I don't recall if Detective Foster told me about it. Question, so this would be early on in the case. The tips were coming in, for weeks, for months, so I don't remember when the first Drake tip came in. So sitting here today, you can't recall when the first time you heard his name in this investigation? No. Now, would your report reflect that? If I dealt with when I first learned it, but I don't recall when I first learned it, so it's not in my report. Do you know if sitting here today, years later, if Drake's name is anywhere in your report? No, it's not. It's not. What about Migos? No. But actually, the first time that you heard the word Migos, the first time that the word Migos comes out in this investigation is not from my lips, but it's from your own when you spoke with the cooperating witness in this case, July 2018, a month after this murder. It comes out of your mouth. Migos, isn't it true? Not that I recall. I don't know if you remember this moment. Okay, do you need something to refresh your recollection? Yeah, I would. I don't even know who Migos is. Okay, may I approach?
Judge, I'm gonna object. He's just gonna read from the transcript, and proper argument.
Overruled, it's not a transcript.
I'm going to show you a statement of Robert Allen and point to page 9. Okay, let me know when your memory is refreshed. Okay, that's his answer to me. Yes, obviously. I repeat it because obviously I didn't know what he was talking about. Yeah, that's Mr. Allen. Mr. Allen mentions Migos. I didn't recall it. And when you mentioned Migos regarding being in a weed hole prior to this, there you go. I have to read the rest of it. Yeah, obviously, it's his phone was breaking up. He saw him, I mean, again, it's breaking up. Do you want me to read the exact quote? Yes, go ahead. Let me know when your memory's refreshed. Okay, so
That
the
would
first
be
time that
good.
Migos comes out in this investigation is from the cooperating witness a month after this murder. I'm sorry, yes. Murder, correct? He's talking about something that's breaking up that I can't hear him, and he talks about a weed hole, then he mentions the word Migos. The word Migos, right? Yeah. So there you go. Because we've gotten a lot of heat, like if we're including people and celebrities, and people think that, no. The person that, Mr. Onfroy was an international rap or entertainer star, and people involved in this happen to be the same thing. It's not hard to understand that. And when you read something like that, I wanted to read it to make it clear that they've been part of this case from the beginning. The first conversation that Robert Allen has with Detective Curcio, that first one, he says the word Migos. Okay? Then he says, oh yeah, I saw some video of like an assault or attack. I think it happened in Miami, but what? So, okay, hold on a minute. The cooperating
Oh, good
co-defendant
Lord.
told you the first time you talked about the word Migos. Then later on, you saw a video of a possible assault that you think happened in Miami, and then you let it go. Because at the end of the day, he was killed by masked men. So the investigation's open. How is it that you don't follow up? Because then I asked him, and then the next time that you heard the word Migos was here today? Yeah. So how is that acceptable? It's not. It's really, really bad. It's bad investigation, okay? And it puts a prosecutor in a bad position to try and prove a case that's already from its inception faulty because of that type of investigation. That should have been followed up, but it wasn't. And there's no celebrity exclusion to murder investigations. I'm sorry. Whether you're famous or not doesn't matter. Okay, your name comes up, let's follow up. You care where he is? Find his agent, get his phone number, call him up and ask him. Do your job. No, I looked at social media. No, unacceptable. And you shouldn't be put in a position to have to accept that as jurors.
Getting there.
They
Like 8,
both,
9 minutes
Detective
behind.
Curcio and Detective Foster, said that they had heard about the post that Mr. Onfroy had left on his Instagram regarding Drake. They also said that they knew that after that there was a hack, that he said he had a hack. But then I asked them both, did you see the post? No? No? You know that a post exists where a decedent is predicting who killed them. You're saying that you know it. Whether or not you think it's a hack or not, as a detective, you're not going to look at it? That's unacceptable. That's tunnel vision, that's unacceptable, and that puts you guys as jurors in a very difficult position.
I know that my chat will always tackle the big issues.
If it was hacked, okay,
And that's
what
why I love
investigation
them.
to see if it was really hacked or not. Because if not, obviously then the post is very, very important evidence in a case like this. We're not going to know because they didn't do it. They didn't do the job. They really owe an obligation to fully investigate things like this. But there was sufficient nexus for you to confirm that he wasn't in Broward County in June 18th of 2018, this is regarding Drake. I believe Walt Foster actually confirmed that. Oh, so it wasn't you? I was part of the team. I'm sorry, it was part of the team. So please explain to this jury when and how you confirmed that Drake wasn't in South Florida June 18th of 2018. I think they determined on social media where he was, but I didn't do it, so you'd have to ask Detective Foster. And then I said, I understand, you made the statement that you were able to confirm that Drake was not in South Florida in June 18th of 2018. Are you telling this jury that the confirmation was simply somebody in BSO looking at Instagram and Facebook? That's the way I recall it. And I'm telling you, as jurors, that's not acceptable. Come on. Look what we're doing here. It's not acceptable. But again, it wasn't consistent with what they wanted. Tunnel vision, and we're not going to look anywhere else. No, these guys, that's it. Boom, blinders. Blinders are for racehorses, not for detectives.
Okay. That was convincing, I guess.
He saw an attack, a physical attack on video, but he didn't follow up. Nowhere in his report. His name comes out nowhere in his report. He said it. So how is that? How is that your partner's looking him up on, you're wondering what his whereabouts at the time of the murder, but his name is nowhere in your report? There are things that they don't want you to know. Curcio, one of the weirdest things that he said on the stand, that he can't be overworked. Really, because every single homicide detective that works in a big metropolitan city nodded their head like, wow, you're gonna say that? Really? And on the heels of getting one of the worst school shootings probably in this nation, months before that, he's lead now, where 17 students lost their life. He gets on this case, I can't be overworked. It's either, listen, it's either not, either he's like that or he's just saying what he wants you guys to hear. Because he doesn't want me now to scrutinize whether you are overworked. But if you are overworked and you're a detective, be honest about it. Don't come in here and lie to a jury. Because that's not appropriate for law enforcement. That's where you cross the line from law enforcement to professional witness. He also has an issue of like believing, he believes Robert Allen. When I asked him, oh yeah, he's always consistent, whatever the guy's a known professed liar. Regarding Keith Grady, is it? The guy from Regal? Yeah, no, he checks out. Basically, what he told you on the stand. Yeah, we talked to him, he checks out. Really, because the guy had a full conversation with Dietrich, and then the state put into evidence where they didn't even, he was unable to identify Dietrich. So is he being honest or not? Because Detective Curcio made it sound like the guy's on the up and up. So that's something for you guys to think about and look at. Is he just rubber stamping things just because it may interfere with his goal? That's the guy that bought a mask next to Dietrich. And I think the guy that sold him the mask said later on the stand that that guy was buying motorcycle equipment, but then Detective Foster said no, that he bought a mask. Again, a state witness contradicting another state witness. That's an issue for you guys. Then you have the cell phone person, Mr. Campaign. Look, they put a lot of evidence in front of you guys in a murder case. A lot of cell phone evidence, a lot of locations, and and he wants to testify that yeah, this is consistent with that. The cell phones are moving in the same direction. You know what would have been helpful for you guys? An expert witness. They could have done that.
Yeah,
that's easy for you. I had expert testimony regarding the cell phones, the trajectory, everything that an expert witness can bring to this case. They didn't.
Very my cousin Vinny.
That's a mistake, and that's adding extra pressure for you guys because he's not an expert. He didn't testify as an expert. So all the cell phone evidence that they're making, that they're alleging is crucial in this case, it could have been provided to you in a much clearer way by an expert, and it wasn't. And that's a mistake. Another thing, Foster went up there and said, yeah, when they arrested the person that they believe is the shooter, Mr. Boatwright, that he had two phones. One of them was processed, and the other one, nah, we didn't do it. You didn't do it? After we've sat here for weeks going through cell phone evidence after cell phone evidence after cell phone evidence, the person that you think is the shooter in the case has two phones, and you decide not to search the other one? Why? That's unacceptable again. There's just things that they don't want you to know. I mean, there's either that or it's complete irresponsibility and horrible police work. Either it's on purpose or it's negligent. Either way, it affects your findings as yours, because that's unacceptable. They also want you to put a lot of emphasis on a cell phone. So if you guys think I have my cell phone on me, maybe not. I'm a child. Maybe I don't want to be bothered. Would you believe if you have a reason now? It's a tough position to put you in. It's yours. It's a cell phone. I can have it on me or not. They're really asking for you as jurors to believe in coincidences. They want you to believe that Mr. Onford went to the bank, took out one $1.25 million, ended up with 50 grand, coincidentally went to Reba, where there was a group of armed individuals with masks, coincidentally with you. They want you to believe that coincidence. That's what they're selling to you. And the way that they've been selling this to you for a long time has been through, and I mentioned this in my opening, how Detective Curcio, because he said that he didn't know that Mr. Onford was famous, but eventually he figured it out, right? And when that happened, trust me, there's pressure. That's an international entertainer that's killed in Broward County, and the whole world is looking for answers, and they're looking for arrests. Make no mistakes about it. You can use your common sense about that. And I talked to you about how he wrapped up his solution, nice and tight with a bow, and he took it to his supervisors. And just like Mrs. Shields brought her little Russian doll, I too like props. So I made this. There you go. That's it. That's the perfectly prepared, perfectly manicured solution that Detective Curcio immediately manufactured, including these 3 defendants, and he took it to his supervisor, division chief, or whoever's on top of him in the chain of command. Look, I figured it out. Here you go. That guy got it, went off the chain of command of VSO, and it eventually goes to the captain. Eventually, this nice and neat solution, gift-wrap solution, makes its way to the Broward County State Attorney's Office, where it's hot potato from different state attorneys, this state attorney, until it lands on Mrs. Shields' desk. And she's coming here and she's done the best she can. And she's extremely talented. You guys know that. There's no mistake. But in the end, she wants you to accept something like if it's perfect when it's not. She wants you to believe that their case looks like that their case is perfect, that their case has no faults. But when you realize and you think about everything that I told you, the lack of the investigation, the refusal to follow up on important leads, the insistence on anchoring your case to a known perjurer that stood up there and lied, all of that, basically, a trial, the way I look at it is every time that this perfectly made little wrap box solution rubs up against the truth by way of cross-examination, by way of witnesses that took a stand, whether you believe them credible or not, if you don't believe, it starts to rub up against the truth. And little by little, this perfect solution, wrap solution, interferes. And as an attorney, I feel like sometimes, like my job is like pet detective when he's kicking the box down the hallway in the beginning. That's sometimes the way that I feel that I have to do when they bring to a jury these solutions, these premature solutions that are fictitious and that involve perjured testimony and that involve all the things that you've seen and all the things that we talked about. And in the end, she wants you to believe that her case looks like that. But her case doesn't look like that. Her case looks like that.
Oh,
That's the way a case looks when it's based on lies. That's the way a case looks when it's based on perjured testimony. That's the way a case looks when detectives fail to follow up on leads.
we're doing visual aids today.
That's the way a case looks when they fail to process a phone of a suspected shooter. When they fail to track down the car that rolled up while the Dodge jury was waiting, when they ignored that.
That's
When
what
they
you got.
allege that Dietrich took an Uber, but they don't back it up with any evidence, they don't figure it out. You don't think that they could have figured that out? Or maybe they could have figured it out because it
Well
took
played,
Robert
right?
Allen 5 years or 4 years to come up with that story.
That's quality right
When
there.
they say over and over that Robert Allen doesn't have a deal, and you hear her say it from her own mouth, that's what happens.
You guys should have asked.
That's what it looks like when you wrap up a bunch of lies and you're trying to sell it. And when you guys go back in there, listen, I know that it's not an easy thing for your position, but they put you in that position. And I want you to understand that there's no way that you can convict Dietrich Williams for not believing Robert Allen. And if you believe that to be true, and I'm talking to all of you, and I'm talking to each of you, if you believe that you cannot convict Dietrich Williams, if you don't believe Robert Allen, and I'm asking you to hold true to that, because it's the just thing. You know what I mean? Like, you can't convict somebody if you don't believe the main witness. You know, when I was preparing for this, I thought about, my life. It was a big case for me. And the reason that I became an attorney is there's an attorney by the name of Jerry Spence. He's 94 years old. He's a fantastic attorney. He's really well known in the legal community. And I saw a mock trial that he did on TV when I was young. I was a teenager many years ago. And that's the moment when I saw him. That's the moment that I knew that I wanted to be an attorney. And in that mock trial, he gives a story. And they say that imitation is a serious form of flattery. So I'm going to try and say it for you guys. I hope I don't mess it up. The story is the story of a smart aleck boy and a wise old man. There's a smart aleck boy that wants to play a trick and fool a wise old man. So he comes up with this idea that he finds a bird in the forest. And he's going to go up to the old man. And he's going to tell the old man, what do I have in my hands? And then the old man's going to say a bird, because remember, he's wise. So we'll figure that out. So he's going to say, you have a bird? And then he's going to say, but is it alive or is it dead? And if the old man says that the bird is dead, he's going to open up his hands and let the bird fly out and fly in the forest. But if the old man says the bird is alive, he's gonna squeeze and squeeze all of it until it's dead, and then he's gonna open up his hands and say, see, the bird is dead. So the smart aleck boy does that. He gets the bird and he brings it to the wise old man, and he says, oh man, what do I have in my hands? And he says, you have a bird, son. And he says, but is it alive or is it dead? And the old man says, the bird is in your hands. And with that, ladies and gentlemen of the jury, I leave in your hands the history of XXXTentacion and the case of the state of Florida versus Teacher Boy.
I'll just take my boxes and go back here.
Next, he tells me it's going to be more than 30 minutes for his argument. And in fairness, I told him I would not have him stop if I had to cut him halfway through and finish off his argument that way. So we will go ahead and recess for the evening. As each time we break, you're not to form any definite or fixed opinions in the rest of the case. You hear all the evidence, arguments, counsel, instructions on the law by me. Till that time, do not discuss cases even among yourselves. During the course of the trial, we take regular recesses during which you're permitted to separate, go about your personal affairs. During these recesses, you shall not discuss cases with anyone or permit anyone to say anything to you in your presence or make attempts to. Tell me on the jury, ask them to stop. Deputies. If you see counsel, witnesses, defendants, anyone else associated with the case in hallway, they will authority do not be moved or following the court's orders. Please make sure to insulate yourself from any media exposure, social media, anything like as you have been up to this point. So just for time, we'll reconvene again at 10:30 tomorrow. Counsel, Mr. Boatwright will give his closing. The state has an opportunity for their rebuttal argument, and I will instruct you, and we'll have it in your hands tomorrow. So with that, thank you for your attention today.
Well, there you have it. There you have it. The day was saved by, for me, just on an entertainment level. The day was saved by the zipper and the box. Oh, okay. So we have one more defense. We had Larry and Curly, and tomorrow's gonna be Mo for the defense, and then he's saying the prosecution has a chance to rebut for that while do a rebuttal, and then I guess they're gonna do. I don't know if they did jury instructions. They'll probably do a little jury instruction conference and then give it to the jury. So my guess is the other guy goes about, they're going about an hour a piece right now. So I'm guessing number 3 goes about an hour. The state really, I think the state will do another half hour after that. I'm making these numbers up, but that's my guess. And there should probably be, they should probably go to the jury. If they're doing it right, they should probably go to the jury early afternoon. There should be a verdict tomorrow on this. They're guilty. In my humble opinion. So thanks for hanging out with me. We never did catch up. We ended up about 2 minutes behind in the end. But that's okay. That's okay. We have the closing arguments. I haven't even looked at tomorrow. I guess I'll try to do tomorrow if I can. I guess that's the plan right now, but I need to get clearance from Yesenia. That's the way it is. All right. Thank you all for coming out. Oh, I might do one. I had one set up for today. I might do a little fun one in a couple hours as well. So I will see you all soon. Thank you.